My lord, may I leave to?
Yes.
My lord, may I leave to mention matters? My lord, those are not appearing in the list. This is new motions.
Motions, please hand over the slip.
On notice, madam.
Please hand over the slip. Motions, please hand over the slip.
Okay. This is with the kind leave. This is a 2014 and 2015 matter, my lord. These are all in respect to, my lord, wherein a direction was passed to the state to file an affidavit in opposition. A specific direction has been passed on 25th September. In spite of they were let them, my lord. 2014 we are sorry. 2014.
What do you want?
Well, I want to be included. Let it be included in the list, my lord.
Under what heading? Hearing.
Hearing, let it be.
Please wait.
Well, only, my lord, lordship, there is a
Please
direction,
wait.
my lord.
Yes.
Lord, I'm seeking your lordship's leave. This is the review application which was being heard by your lordships and the Honorable Justice Supratim Bhattacharya, my lord. Mr. Advocate General was assisting your lordship.
Yes.
Grateful, my lord.
Well, an extension of interim order, madam.
Extension of interim order, please hand over the slip. Have you mentioned when it is expiring?
Yes, madam. On
Please
30th
hand
of this month.
Motion is appearing before the monthly list of
New motion.
new motion September, October is not
Please
appearing.
hand over the slip.
The change in determination is not appearing.
Hand over the slip, Mr. Mughal.
My lord, for non-prosecution.
Non-prosecution, hand over.
Get.
Two mentioned.
My lord.
Yes.
My lord, this is contempt application, my lord. My lord, actual
Contempt, hand over the slip.
Hello, included in the list.
Under what heading? You don't know, please ascertain, then mention. Yes.
Motion.
My lord, I have understood my lord's intention. But facts
What
remain.
intention you have understood?
The intention of the hearing matter, my lord, should.
Hearing,
But
please wait.
it's a long-standing matter. It's a part of Mr. Justice Subhendu Samanto. Time to time it was heard. Mr. Ashok Banerjee for Hatko and Mr. Chondi Chowdhury for state. I am for the petition. Time to time we heard. We are really suffering. My lord. Let it be.
Come in the next week, yes.
On the listed motion, this matter earlier occasion, my lord, heard by my lord Justice Aniruddha Rai, when he, after hearing his lordship directed
Listed
to
motion,
appear
hand
as
over the
listed
slip.
motion, my lord.
Hand over the
Three analogous matter, I have served notice.
hand over the slip, listed motion. Yes. Call the list. Yes. Correction. It has been pointed out that the year of the yes.
Lordship, I appear for the petitioner. It's for extension of interim order which is to expire on 26th of
Who
November.
is appealing for the other side?
Lordship, for respondents.
You are for the other side.
Election for affidavits were also passed, Your Lordship. I am filing the affidavit in opposition on behalf of the Book Trust.
Lordship, may I file use an affidavit to the opposition?
Yes. What is the matter?
Lordship, it's with regard to allocation of a land under a circular based on first right to refusal. I am a sitting occupant in the property, Lordship. I have been held to be a lawful tenant.
All right. If it is service, if it is in opposition, you are filing today.
Yes, Your Lordship.
If it is in opposition,
I've just received a copy, Lordship. May I file a reply to this?
if it is in opposition, filed in court today is taken on record.
Similar order.
Similar order.
হ্যাঁ একই তো হবে আর কি
I appear for the respondent numbers 2 to 6, my lord.
Respondent number 6.
2 to 6.
2 to 6.
Lord,
Who is for the state?
state appearing.
But not now.
But
Yes,
today they
Mr.
were
Basu.
one can extend the interim order until
What
further
is the
order.
issue?
Issue is, my lord, I take the land with the concurrence of the state government,
You
take the land with the concurrence of the government of a leasehold property,
He-
leasehold property
assigning
of
of
an
lease.
earlier
I
one.
have terminated, I want him out. This is what the facts are.
There is
WPIIDC is the
Nobody.
lessor. We have terminated. Now, my lord, they've got an interim order, my lord. I'm only praying, my lord, any day convenient to your lordship in the next week or in the second week of
শুনলি না
December.
intention?
I want to.
একটু আগে শুনলি না
termination
intention?
of lease, Mr. Basu, how can it be challenged in a writ petition?
That we are covered. The Article 12
You are
authority.
covered.
Article 12 authority, REIT is maintainable.
No resumption
Contractual rights, Mr. Basu,
My lord,
even if it is Article 26, one of the contracting parties is an
not
article.
only that, the statutory provision of establishment of the organization is to leasehold land. So that is their statutory duty. It is not the establishment, my land expense client established on a statute only for this purpose, not for any other purpose. That's the distinguishing feature. Say for merit. And there is no resumption because that is on merit.
No resumption.
He is asking me to prompt your lordship that there is no resumption clause in spite of that resume it.
No arbitration clause either.
বাঁচার রাস্তা নেই লাভ কি এটা হলে আরেকটা হবে
The
টাইমলি বলতে এই মহা মুশকিল
this interim order is still
November end.
November 30.
affidavits exchange.
Yes, sir.
no affidavit not
I'm
exchanged.
the
No, when I say no,
Report in the form of.
Who has not filed the affidavit? State.
none file affidavit. There is no direction for
given-
filing affidavit.
Who is for the state?
State it's recorded, my lord.
State is not the answering respondent.
My lord, I am the answering respondent. my lord.
Yes.
There is
but-
no affidavit.
Kindly seize my report supported by affidavit on behalf of
The
respondent.
report nowadays is report is there.
Well, it is just-
If they want to,
But my lord pass a direction for affidavit. Thereafter it will be said that no direction was there, so we have not filed it.
well, they've dealt with the report. They've taken an exception.
Report is not the affidavit.
let me see if there is a necessity to file an affidavit of opposition. Report is not sufficient, then I will.
Then again এগুলো delayed.
You will be benefited, Mr. Basu, for that.
কত benefit হলো?
সবাই মিলে. The interim order is a
It's hearing message.
appellate side.
This is not nowadays. There is no difference.
This is matter under the motions because I have refused many who came for mentioning for hearing.
I understand,
That's
my lord.
the
But my lord, if in December, I'm not asking for this side of.
This side ও চাইবি?
My lord, in December, any day, my lord.
December.
Yes. my lord.
Let me
Second
see if,
December, I'm willing, my lord.
if
I want to
possible,
come-
I will include that in the monthly list. of-
And my lord,
If possible, my lord is fixing the purpose for hearing. If possible, can you extend it until further order so that matter can be heard out?
Mr. Basu, it will benefit you if
No,
prior,
we don't require.
prior to February, Mr. Basu, if it is not taken up, it will be beneficial for
No,
you.
no, sometimes it is a beneficial, not beneficial also. Sometimes, not normally.
Yes.
Okay,
But I'm also appearing.
don't record his name.
Yes.
man, any day in December, it's not.
Let me see. Yes.
Well,
Where is-
Man, let me
Yes,
Mr.
sir.
Majumdar, my lord. Let me Mr.
where is Mr. Majumdar? Has he come?
Protested, yes.
I am for the petition, my lord. But I'm assisting Mr. Basu. my
Here
lord.
one.
Yes, yes, my lord.
Item number 4, 5 and
TV screen.
He claims to be assisting you.
He claimed to be assistant. I'm disowning.
Did you get any assistance from him? Yes.
my lord, item number
Hey.
4,
Yes.
Item number, I am for the petition. Item number 4, 5 and 6 are identical, only
Yes,
the
what is
difference
this
is the
matter?
In item number 4, my lord, on Friday, my lord, I have received the intimation that I have been engaged, my lord. I have not received the hard
You are for
copy.
the
I am for the state. I am led by the
State.
Learned Junior Standing Council, my lord. So, my lord, I am humbly beseeching your lordship, my lord, kindly adjourn this matter for
what is this matter?
My lord, the petitioner's plot land was requisitioned under the Defense of India rules under the 1939. Subsequently, it was continued under the Bengal Act 1948. At the relevant point, it was 1951 Act was applied, but no award was ever passed. Thus, if the petitioner made for representation for compensation, that was not considered. He came up before this honorable court. Honorable Justice Subhra Ghosh was pleased to direct the special LAO to consider the
Where
representation.
is that order?
My lord, page 120.
What happened after that?
My lord, special LAO passed a order, rejected our prayer for releasing the matter.
You are challenging that order.
No, we had already challenged. My lord, this is the 4th round of litigation.
Then what happened after that?
Thereafter, we again came up. Honorable Justice Aniruddha Rai was pleased to set aside the same and directed the special LAO to reconsider afresh. But in this impugned order, which has been challenged, that impugned order has been challenged before your lordship.
Thereafter also again an order has been passed.
Order has been passed, but so far our prayer for releasing the land is concerned, that is silent.
Where is that order? Which you are challenging?
on page 133. In our
133.
No, no.
133 order impugned, so it 133.
130. The earlier order was at page
Please give me
120.
a minute.
The order dated 11/9/2024.
গাড়ির নাম্বার হচ্ছে
Where is the representation
My lord,
for non-consideration of which you
page
approached
115.
Justice Ghosh?
Page 115. Prayer
115.
portion is at page 119. But we paid for release as because as on that date,
Please
there was
give me
no
a minute.
valid
Please give
requisition.
me a minute.
বলছে তুলে দেবো
Where is the order passed pursuant to Justice Ghosh's order?
Page 125. That impugned order starts at page 126.
এটা তো রেন্ট কম্পেনসেশনটা ছিল না?
না, এটা এই প্রথম যেটা রিপ্রেজেন্টেশন দিলাম 22 সালে,
এটা তো রেন্টের কম্পেনসেশন ছিল 2016 অব্দি পেমেন্ট
এটা 16 জাস্টিস কালিদাস মুখার্জি order,
কালিদাস মানে তপেশ মুখার্জির order।
তাপস মুখার্জি।
Yes, now they have opted for the direct purchase policy.
No, what the direct purchase, they have, Lordship, here are some documents also, from my lord will find that they had the proposal for de-requisition, but that was never acted upon
Where is
since
that?
2010.
Where is that?
My lord, page 59,
59.
my lord. The 58 starts from 59, and it's a P10.
হোয়াটসঅ্যাপ করে
Type 2 copies are also there.
No, there are two things. You wanted, initially it was requisition.
My lord,
So you received rental compensation till 2016.
my lord.
After that, did you receive any rental compensation? No. So now, but the fact remains that it's under possession of the authorities. Now the authorities, they want to purchase it under the direct purchase
My lord,
policy. What is your submission with regard to that?
My lord, as per by operational law, as per decision decided by the special bench of this honorable court, as well as the another division bench subsequent in 2011 and 2012 respectively, my lord, we are entitled to get back the possession.
If the judgment.
ডিসিশনটা বলবে?
TLJ volume 2000. Relevant paragraph is paragraph 7 and 8 at page 497.
This is Shobita Mondol.
My lord,
That was under Act 2 of 1948.
my lord.
Act 2 of 1948, after expiry lapse of that provision,
96
if no
amendment.
steps is taken.
Yes.
So
I am standing on similar footing. And as my compensation was
and where is the other decision? Passed by Justice Sengupta?
no, it was passed by Honorable Justice Pranab Kumar Chattopadhyay and Justice Tarun Kumar Das.
That was also on Act 2 of 48.
The year 96 Amendment Act has been dealt with.
Yes. The effect of not converting the requisition to acquisition under the
And
Amendment
non-payment
Act of
award
97.
within 1 month from 1st April 1994.
These propositions are well settled.
But I am on similar footing, but I am paying for release. So far, their demand for direct purchase is concerned. Let's say here also, the state is trying to cheat these petitioners. Well, I am embarrassed to say. Lord, my lord,
Are you willing to
no, I
direct purchase policy?
no.
Sir, if they do not, if they're not willing under the direct purchase policy, you cannot force direct purchase
that is
policy
the
upon
reason,
them.
that is the reason.
Either you take steps for acquisition in accordance with the new act, or you release that.
In response to
That
their
is the reason, my lord, I am humbly beseeching your lordship, my lord, kindly grant me a week's accommodation. In the meantime, the officers will come, my lord, I shall, my lord, get back with proper instruction with regard to, my lord, the next step to be followed.
The petitioner alleges.
Lord, we had offered to sell direct purchase at the rate of 18 lakh per soto. But that has not been considered also. They will not consider.
That is a different thing altogether. So you can say that, yes, I am agreeable under the direct purchase policy, but the market value or the price is to be decided as per this rate. That's one thing. The other thing is that you don't want that direct purchase policy, then it will be as per the 2013 Act. Then the entire proceedings will continue, steps will be taken. That's
Lord,
for you to take a
My lord,
decision.
they asked for
Upon taking instructions, please think over this matter. That is why you also have to take some instructions in this matter.
My lord, what I have got, my lord.
That's open
What
to you
happened
whether to accept under the direct purchase policy or to go under the 2013 Act.
in respect of their
The grievance of the petitioner is that the possession of the property of the petitioners have been withheld illegally without taking any steps for acquisition of the properties which were requisitioned under the provisions of the
Defense
which
of-
rules.
Defense of India rules, 1939.
কি বললাম, which was requisition বলেছি তো, under the provisions of tight over that direct purchase policy for eternity.
Let the matter
So-
remain in the same position, my lord. Let the matter remain in the same position.
That's said under the same heading, same position. It's
Get-
not in my hand.
Careful.
Yes. Next. 4, 5, 6.
And
Same.
six.
You are appearing in
We are appearing for the state respondent.
5. Yes. What is your submission with regard to 5?
Malan, I don't, till date, I didn't get any information from the department, but as I find from the writ petition, Malan, there is an order passed by this honorable court.
তিনটে order আছে। তিনটে order আছে।
The last order, as per,
Passed by the
by this honorable court. And
Yes.
as per this honorable court's order, Malan, page 74.
yes.
Malan, this
Something
order, I find, Malan, the penultimate paragraph, Malan,
74.
page 74. Malan,
Yes.
here I find now today during the course of hearing, the petitioner have prayed for to hand over the suit plot, the DCFS.
You
Purvo-
want to purchase it under the direct purchase policy. What is the stage where it is pending for
that
consideration? At
particular,
what stage?
yes, Malan, that particular instruction I don't have presently, Malan. In that case, Malan,
It is also requisition under the same.
My lord.
Same.
Only plot number, adjacent plot number. is
Same
different.
order.
as well as,
2nd December. Next.
Malan, I'm grateful. to this.
This is also identical.
6 who is appearing. You have also not got any instruction.
My lord,
My lord, I am for the respondent number 10 and 11 ONGC, my lord.
Private respondent.
ONGC.
No, no,
my lord.
ONGC. This is the
ONGC.
video service.
ONGC is 10 and 11.
My
Who are 1 to 9?
My lord, the state respondents. State respondent.
My lord,
Who is
this
for the
video-
state?
video service. My lord, this is the video service. My lord, what happened in this case? My lands has been acquired by the LA case number in the year 76 and 77. My lord,
ONGC is the requiring body.
It was the
this is the
required-
recording body. My lord, what
What
happened?
happened?
My,
Under which act?
LA Act.
Act 2, my lord. Act
LA
2.
Act in the
Act
year
2.
1976, 75, but no compensation has been paid. We filed an application, but they did not consider it. We came before this court. This honorable court direct passed an order. Honorable Justice Ravi Kishan Kapoor was there. He was passed an order on 11th September 2018.
Page
54. Page 54, my lord.
54.
54. May I,
Yes.
may I read my
Consider the representation.
consider nothing is consider the representation after within 8 weeks, but they did not consider. We filed an application for contempt. My lord, contempt petition, but contempt petition is pending. At the time when the contempt petition came up, my lordship kindly come to page 64. Page 64.
Yes.
On 29th July 2024, when contempt matter came before this court, May I read, my lord? It is submitted on behalf of the petitioner that nothing has been direction of the alleged complainant has been considered represented such and such. On behalf of the alleged complainant, it is submitted by an order dated in order the representation of the petitioner has been duly considered in compliance with the order dated such and such.
Where is that order?
My lord, that order has been then and there they served a copy in the courtroom. Then that order is, my lord, last page 92. Page 92. May both parties appeared and filed hajira. The representative of the ONGC submitted a written report. Seen the report, heard both sides. Abdul Kalam, the petitioner, stated that he did not receive any compensation of plot number 246 Mouja Angespur for his land measuring about 79 decimal land. He claimed compensation and land possession along with previous condition of the land character. The representative of ONGC stated that 6% RC of the suit land was disbursed. The representative of the ONGC stated that they have submitted de-requisition proposal.
What happened to the proposal for de-requisition?
Nothing.
Yes, Mr. Ghalib. What happened to the proposal for de-requisition?
My lord, as on date, my lord, I contacted my lord, the update has not been given to me. Now, may I be given some time to come with the instruction on this issue, lordship?
When have you served the copy?
My lord, every service to come.
Upon the land acquisition officer.
Copy for question. Copy.
His prayer B may be granted, lordship. Prayer B,
Prayer B.
lordship.
What is prayer B?
He's asking for to consider representation that is should be.
Representation consideration, today an order will be passed. Thereafter, after 2 years, contempt application.
May I
will be
come up with
filed.
an instruction?
Then we will say, please give me some more time. I will pass an orders.
Well, kindly give me a week, my lord, so that I can come with this.
Yes,
instruction,
yes, requiring body, what steps have been
Requiring
taken
body,
to release the requisition compensation?
my lord, kindly comes to page number 56, the order, recent order passed by the LA collector, my lord.
Yes.
The last 2 points. My lord, hence a letter to LR department will be issued
56.
for 56, my lord. Page 56, Annexure P7.
Yes.
This was the recent order passed, my lord.
Yes.
Hence a letter to LR department will be issued for approval of the requisition of the suit plot. And my lord, the requiring body is asked to pay compensation for utilized suit land as
Yes,
per
the requisition that is pending consideration at
pending
their end.
consideration, my lord.
That
Pursuant to
Mr. Ghalib
Lordship.
take instructions and what with regard to you have to pay the compensation. What happened
pursuant
to
to
the
this order,
compensation?
my lord, we have written to the my lord LA collector that kindly
No, LA collector will pay provided you deposit that
my
amount.
lord, the LA collector needs to my lord inform us the amount, the exact amount of the compensation.
Ghalib,
But
where will
that
you
later
inform
we
the
have
amount
issued.
also?
Lord, I have contacted me, lord. Kindly give me a week from date,
No,
lordship.
maybe now you have contacted, but this was an order of 2019.
No, I have, my lord.
An order passed by you,
Lordship,
in 2019.
lordship, I fully, my lord, I don't stand in the way of the petition.
Now you are saying yes.
No, the moment I received,
to be allowed.
my lord, the moment I
After
received,
6 years, you are still at the same stage, Mr.
the
Gali.
moment I received the writ petition, I contacted the, my lord,
Maybe I am not blaming you.
lordship.
The moment you have received, you have asked. But what the authorities were doing for 6 years,
Lordship.
the order passed by the LA collector, what the authorities were doing merely by passing an one-line order, yes.
Lordship. Fully approved, lordship.
Tomorrow, I'm keeping this. Please take instructions.
Kindly, my lord, give a week,
6
lordship.
years, Mr. Galib, they have to take now prompt steps. I will not allow
No,
6 days, Mr. Galib.
There's some judicial.
After 6 years, not 6 days.
Kindly give me some judicial grace, my lord. Some judicial grace, my lord. I have contacted with all humility and with all earnestness,
I'm not
lordship.
blaming you, Mr.
No,
Galib.
with all, this has to be taken
6
care of.
years.
Kindly give me, my
And
lord.
that too, you did not communicate. When the contempt application came up, you said, I have passed an order.
Lordship. Kindly keep it on Friday, lordship, so that I can come up, lordship.
take instructions.
Not sure.
If you find that necessary steps have not been taken, please come with some definite concrete thing. From where it can be understood that how much time it will be completed.
Not
Don't
sure.
take the pleas of other processes which are going on in the meantime.
Not sure. Not sure.
Yes, next.
My lord, every service be kept on record.
Every service filed in court today is taken on record.
Keep the
Yes.
My lord, I am waiting for the state respondents.
Yes.
Illegal construction made by the private respondents
On
the PWD road, my lord.
PWD road.
Yeah.
My lord, I have received instructions today in the morning in terms of
Yes.
instructions, my lord. On 22nd of September, we have already approached the BLLR, my lord.
For demarcation.
My lord. And thereafter, we have also sent a reminder. It's on 21 of November. The both are in the annexures, my lord.
You are representing the BLRO also.
My lord.
So, what is your instructions from the BLRO?
My lord.
This is your instructions from the assistant engineer.
My lord, my lord.
So, what is your instructions from the BLRO?
My lord,
Why he is sitting tight?
my lord, let there be a specific direction upon the BLR, my lord, to dispose application immediately without any further delay.
You are not interested in removing encroachment.
Absolutely, we are, my lord, but unless, my lord, the demarcation is made, my lord, we cannot approach.
It's your one wing of your.
Absolutely, my lord, I admit, my lord. So, my lord, kindly there be a direction,
How
my lord,
much time you take?
on BLR, my lord. 6 weeks, 6 weeks, my lord, as usual.
6
weeks, 4 weeks.
Private matter.
Yes, my lord.
Yes, similar advocate, yes. Nobody, oh, you are appearing.
State led by Mr. Sengupta, my lord.
Mr. Sengupta, where is Mr. Sengupta?
We code number 30, my lord. He is a log.
Same thing.
Yes, my
What is your instructions? Have you also written a
I have
letter to
received
the-
instruction from the inspector in charge, Korimpur. Police, my lord. I have not.
Will not do. All right, I am making it not today. Mr. Sengupta is having the instructions or not?
That is, I have not.
Same locality.
Yes, my lord. Same locality.
Why? Your unauthorized construction has been demolished.
Yes, my lord.
Your unauthorized?
No, my.
No. Then why are you trying to remove all shop rooms?
Shop rooms. Shop room.
Your shop room has been removed
No,
by the private respondents.
private respondents.
Your shop room has not been removed. Any other dispute between the private respondent and your client?
No, others.
No dispute.
No.
Not today?
Not today, my lord.
Not today and tomorrow, my lord.
Why? Tomorrow you will not be available. Where is Mr. Sengupta? Ask him to come. Pass over. Yes. Yes.
There is no scope for interim order. You may not want pending application. of
There is scope for
1991.
admission, Mr. Basu.
Oh, that is all. Admission.
Admission of the
So
petition.
only one honorable judge I have heard in this petition to be admitted.
Yes, yes. What is this? What is this?
Under that.
ললিতের accent নাকি?
Oh, judge জানে। 1948 Act, the temporary provision, the property was requisition. 25 years passed, challenging that requisition, a writ petition has been filed.
Not followed by 9(3) and 9(3)(b).
No. No. Temporary provision,
Oh.
25 years. After that, my lord, the property, that was challenged. That the writ petition is required to be heard. Yet the writ petition is filed on the ground that it
There the
come
writ
back.
petition is to be heard. That's pending. When writ petition was
1991.
91. That has to be heard along with this. That's why I said there is no scope for interim
Yes,
order.
now what is the scope of this?
Now, my lord, we are asking for that, give it the property to me, and if you want to take it under the new act, you have to acquire it. This is a sum and substance.
My lord, yeah, my lord,
For the
I am for the state, my lord.
Mr. Banerjee,
Requiring body, I am for the.
Body, only one.
supporting Mr. Basu.
No, cannot be.
No.
I'm not supporting. And in 2014, my lord, the possession has already been handed over to Lord Calcutta Tramways Company. We are not
Calcutta?
in possession.
Who are you?
I am South Bengal State Transport Corporation. Initially, it was given to
South
us.
Bengal State Transport, Calcutta? To whom you have handed up?
CTC, Calcutta Tram Company. As per the,
No existence now, Mr. Banerjee.
it has merged with
It-
the Transport Corporation.
Say so. To whom have you handed over?
He is also part
At
of
that
Transport
point,
Corporation.
2014. No, I am not part of Transport. It's a separate. SBSTC is separate till then.
The advocate may be a part of transport.
No, that is not at all. But the company is-
Initially, it was not Tram Company to whom we have handed over in
Let him
2014.
as a part of
2014. Then it has merged with Lord
South Bengal Transport, no, now it's West Bengal Transport Corporation.
Corporation.
Mr. Basu, then you have to add
Can you give us
West Bengal
and-
Transport Corporation. Yes, now what is your
Second
submission?
submission is Lord that in the other matter also we have filed our affidavit. It's a Lord 60 land. So their title, I am challenging kindly my records Lord that we are challenging their title also. If it is a 60 land, then the Lord status of the person retaining is Lord lessee. Now whether lessee Lord can transfer, Lord, that is the question. We will kindly Lord,
Lessee has transferred to whom?
it has been
The
Lord,
company has transferred to
He
the
is the
petitioner.
transferee from the
To
lessee.
the petitioners.
Anything has to be argued. This another Sikh Act overriding effect.
You know,
I
let
come to
there,
that later.
let there be, let there be a direction for opposition, my
Yes,
lord,
yes.
with the preliminary objection maintainably kept open, lordship.
Can I keep it? No problem.
they have acquired through SICA Act and they say that act overrides all other provisions.
I know, don't say. Section 32 says.
After hearing the learned advocates for the respective parties and considering the nature of the reliefs claimed in this writ petition, there is no scope to pass any interim order.
can wait, but this matter,
I will consider, please, because let the time limit expire.
no, after time limit, can you fix the date? If
Mention-
pilot is there, we can take that.
Without
advantage of that.
liberty, Mr. Basu, your juniors are also mentioning. I'm not saying you. Your juniors are mentioned.
I don't mention, that's true.
That is why I've said.
Only thing, my lord, if your lordship say that matter is fixed after the period, if not appears, then you can mention. After the period is over.
I've said so. Liberty to mention after the extract. Yes, next.
My lord, it is that matter. When the my lord Purva Mendipur were Jila Parishad approved fund for construction of Mahatpur Primary School, from Simmonti to Mahatpur Primary School. My lord,
So they give me a minute.
Well, this is a report, my lord. Jila Parishad, my lord,
the
report.
report is in my favor by the Jila Parishad. দর্শককে তো দিতে হবে রে ভাই। আমাদের তো করতে হবে। কই আরো এখন আমাদের
Bhai.
আমাদেরটা এখন করে আমাদেরটা এখন করে
Yes, where is the report of?
My lord, report. Copy দিয়েছি।
Mr. Bandyopadhyay, what is?
My lord, I'm filing that. Some marking is my lord necessary in my copy. I have not got any copy, but I have got the copy of Jila Parishad.
Mr. Bandyopadhyay, you have not served him a copy.
Well, I have served, my lord.
I have got.
Upon all.
Jila Parishad my lord is in favor. You know, but I'm handling it. আমাদেরটা করি।
But he needs time, Mr. Bandyopadhyay, to go through this. He must be.
On the last occasion. 28th, my lord, but we could not, my lord. But R1 করে দাও। আরে মার্কিংটা করো, দর্শককে দিতে হবে সেটা। এই দর্শককে দিতে হবে। এটা কি? 7 পাতা কি? দর্শককে দিতে হবে না? লাস্ট 11 বছর। দর্শককে
Yes, Mr. Bandyopadhyay, what is your report? What have you said?
states, my lord, in page 3, my lord, Roman 3:1.
আপনাদেরটা কি আছে? না, এটা থাকার জন্যই আমরা করেছি।
আপনারা করেছেন না করেন?
না, করেছি। ফুল জায়গা কাজ কমপ্লিট করে দিয়েছি।
কাজ কমপ্লিট করে
কমপ্লিট করে দিয়েছি। এটা থাকার জন্যই দিয়ে দিয়েছিল।
তাহলে তো মুশকিল হয়ে গেছে।
যদি গভর্নমেন্ট বলে যদি প্রমাণ হয় যে রাইট চেক, উইল রিমুভ দ্য সেম।
জেলা পরিষদ তো কমপ্লিট করেছে না?
হ্যাঁ, করে দিয়েছি।
মুশকিল হয়ে গেছে।
কারণ যাতায়াতের জন্য ব্যবহারের জন্য বলার জন্য
আপনি তো বলেননি আমরা অ্যাপ্রুভাল।
না, সেটা বলছেন না।
Even recording of POT is a private.
What is in the record mill? I cannot. Behind my back. I cannot alter mill. What is in the record mill? That is my direction.
Then what do you now propose to do? Construction of a road has been made.
My lord, from my learned friend, Mr. Bhattacharya, my lord, I came to know that the road has already been constructed by the Jalapur.
Then what do you want to do now?
It has been, my lord, constructed by the Jila Parishad authority. My lord, we have not, my lord, constructed.
No, video.
Video
is the main culprit.
About
When the fund was allotted for construction of Mahatpur,
bad allegation, my lord.
আমাকে তো বলতে, আপনি তো উল্টো বলছেন।
Mr. Bandyopadhyay, please see the report of the Jila Parishad, paragraph 3. Jila Parishad, paragraph 3.
2 also.
2 and 3.
Under the supervision of the block development officer,
Supervision of the BDO. So,
he is the executive officer of the Panchayat Samiti.
yes.
Therefore, my lord, all, my lord, the project of the Jila Parishad, my lord, the 3-tier Panchayat, my lord, your lordship knows, my lord, Gram Panchayat, Panchayat Samiti and Jila Parishad. But in the Jila Panchayat Samiti level, my lord, BDO is the executive officer, my lord. Then he has to look into the matter, my lord.
Now, if the construction of a road has been made, utilized So you have to compensate him, Mr. Bandyopadhyay.
ভিডিও রিপোর্টটা দিয়ে দাও তবে মাইলটকে না দিলে কি করে বলবো
May I submit one thing?
আগে মাইলটকে দাও
Previously, PDO has take attempt. I approved you the civil code. Civil code said, please demolish and withdraw and remove that road. Video failed. Video was part
Yes,
in the.
video has given a report, Mr. Bandyopadhyay.
Yes, Milo.
Where is that report? What did he say in this report?
মাইলটকে না দিলে কি করে বলবো
What did he say in his report?
দাঁড়া ওরকম ভাবে বললে হবে না ধুমধাম ব্যবসাকে মাইলটকে ভর্তি ভুলভাল বললে হয় Work order has been issued by the Miller Jira Police. Paragraph 4. 3 and 4 Miller Dear Lord Kindly see.
Yes, Mr. Bandyopadhyay, what steps he will take against the BDO? When the civil court has directed demolition of that, and he says some private parties,
Then it will be carried out by law.
some private parties have requested and he has constructed.
But if it is done, well, it is wrongly done. Well, then it will be
Desperate attempt.
Then
With
it will.
hooligans.
Then
Please see, have you seen the report of the?
Just now I have hand.
I'm keeping it tomorrow. Mr. Bandyopadhyay, please go through that because the BDO has said earlier a civil court directed him to demolish. Please demolish this. No payment of compensation at your own cost. How soon it will be demolished? In this way, you cannot take the property of a private person.
Yes, your lordship is correct, my lord.
And the BDO seems to be very smart.
My lord, if it is done, my lord, it is wrongly done, my lord.
Asking some persons
order
to
will be
submit
carried
a
out, my lord. Your
representation.
lordship pass the necessary order.
I'm giving you time tomorrow. Please take instructions.
Lord.
What steps you want to take, then I will consider.
To remove the road. My lord.
Let me see what instructions he comes up with. Some other instructions it may be acceptable to your client also.
Carry out, my lord.
Because
Let him come with some instructions. Some instructions your client may be willing to accept also. Nobody knows. The
Regarding item. Lordship, in item number 12 and 13, I am praying for a week's accommodation
Why?
to file my exception, Lordship.
Exceptions, report has been filed.
Report has been served upon us, Lordship. Your Lordship on the 10th
Well,
of
may I file my
November
report?
has
Yes,
directed.
Mr. Bandyopadhyay, what is there?
It's my lord 13 report, item number 13.
Item number 13.
It's between
Yes,
the
12 and
same
13.
party.
Same.
Same
What is
party
this
that
matter? What
two
is this matter?
Two land acquisition proceedings. That's why two writ applications.
Land acquisition proceedings.
Two LA cases we have challenged that the notices were given and the
9
notices have
3B
lapsed.
was given thereafter.
9 3B notices have been lapsed, Lordship, and no compensation was paid.
What is the report?
And it's not
Hey, din report ta din. Yes, what has been stated in the report?
The land has not been utilized, my lord, they have taken, not it is acquired, my lord, not utilized.
You are in which writ petition? 1088.
Yes.
1088. Show me which paragraph you have stated that.
Page 5 million. তার আগে বলেছো? কোথায় বলেছো? কোথায় বলেছো দেখো?
I just come back with a exception.
When neither acquired nor taken possession.
There are 3 million. There are 3 million.
Yes, paragraph 3.
Roman 2.
So I record this. What remains?
Lordship, may I just come back with
In
the
your possession, it has not been
no in my
acquired, not taken possession of.
in
You are
my
free to
my
utilize it.
instruction, Lordship, my instruction is that the land has been acquired. There was a dam that has been created and it has been utilized by the state, Lordship. It is my instruction. That's why I want to submit an exception to this report. I am seeking only a week's
Instructions,
accommodation.
instructions will not help. How do you say that your lands have been utilized?
It is there, Lordship. May I just
Where is
just
the
come back
Mr.
with the
Bandyopadhyay? Have you
order
annexed the
affidavit.
notification?
Notification দেওয়া আছে?
And Lordship, another thing, your Lordship has directed them to submit a report in connection with LR plot numbers, Lordship. The reports has been submitted as of CS plot number.
CS plot number.
Your Lordship has directed in your Lordship's order to file in connection with LR plot number. So your Lordship's order dated 10/11/2025.
7 million. Notification letter. এখানে কিন্তু ঠিক পজিশন সার্টিফিকেট এখানেও নেই।
Yes, Mr. Bandyopadhyay, the CS plot numbers have been mentioned. So what is the corresponding LR plot numbers? Because he refers to the LR plot numbers.
The RS plot is there below. In the possession certificate also annexed below the page 11. LR plot is there. It is in the year 79.
Where is you have purchased this property?
No, Lordship, it has been inherited. It is the
Inherited.
property belongs to my father, Lordship.
Show me the record of rights.
May I just, your Lordship, kindly accommodate. I am led by Mr. Ron Banerjee in this matter, Lordship. May I just
Mr.
come?
Bandyopadhyay is a busy counsel.
May I just come back there since the client is suffering from illness, he could not come and affirm the affidavit exception.
No, that is all right.
In only 1 week's time. By the Monday, I shall file. I shall affirm and serve upon the respondent's Lordship. If your Lordship may kindly grant us an adjournment for a week.
What is the name of your father?
Vinod Chandra Das.
No, who is Govindo Das?
দেওয়াতে হবে টাকা পয়সা দেওয়া হবে চলে যাও চলে যাও চলে যাও চলে যাও চলে যাও চলে যাও ওখানে চলে যাও আমাদের 16 নম্বরে মামলা 16 নম্বরে চলে যাও
Do you have your record of right standing in your name
Lordship.
or your predecessor's name? Where is that?
It's in the name of my father. It's page 18, Lordship.
Vinod Chandra Das.
Vinod Chandra Das, Lordship.
What are those plot numbers?
It's 915, 916,
900,
915,
915, 16,
944, 963,
944,
963,
963.
1006, Lordship. It's in the
Next page. 1000,
1006, third
1006, yes. How do you say that it was acquired? It has been recorded in your name,
Lordship.
still recorded in your name. It's difficult.
You kindly take page 29 of the writ application, Lordship.
Page
29.
Yes.
It has estimated as per amendment. It has been served upon me, Lordship. It belongs to the jail number 164, Lordship. My plot is at jail number 164.
Jail number 164 does not mean all plots of jail number 164 has been acquired.
Lordship, may I just
Maybe
start
in the same
on affidavit,
jail
may I just
number.
come back, Lordship? Only this week's time, Lordship.
Only
this week. I come back on Monday with the affidavit, Lordship. So kindly.
Only, my lord, I don't know no.
Yes, yes. What is your submission?
My lord, in the earlier occasion, my lord, in the order, specifically, my lord stated in the we directed to us the state to make a report in form of affidavit upon the some specific LR plot number, my lord.
Yes, yes.
405, 406, 518, 797, 802, 821, 822, 856, 840, 857, 879, and 917. Where is the Mr. Oyanbaji London Senior, my lord, keep submission, my lord, and my lord, please to pass this order upon these plots, my lord. And we made the report on the specifically on these plots specifically, my lord. And
what are the corresponding CS plot numbers of these plots? Unless you say that, because your original schedule is as per the CS plot numbers. Unless you say in your report what were the corresponding CS plot numbers, how do you say, what is the basis of your saying that it was not acquired? You have said, you have given the CS plot numbers.
Yes,
and you have said these plot numbers were not acquired. What is the basis? Unless you say the corresponding CS plot numbers of these LR plot numbers. Mr. Bandhavata, please take instructions. What are the corresponding CS plot numbers? Otherwise,
I shall try, my lord. I shall try.
Maybe by this affidavit, what is the basis of your?
Number is mentioned there, my lord.
Yes, but now in the schedule it's only CS plot numbers, and in the notification also is the CS plot numbers. No, notification is RS plot numbers. But the document which you have annexed in page.
But in the paragraph, my lord, 3 has not stated what is the whether it is RS or CS or LR.
That is why Mr. Banerjee said it's LR. I have recorded in the order as LR.
P1 here annexed, that is the LR.
Yes, because Mr. Banerjee, if you kindly come to page 6 of your report, This is the public notice.
My lord.
This refers to only CS plot numbers.
CS plot number, my lord.
Now, if you kindly turns over to page 7,
Page 7.
this is also CS plot numbers.
Yes, my lord.
Now, kindly turn over to page 8.
8.
No, this is which district?
That is for continuity.
This is which district?
Yes. Uttar Dinajpur.
This is
Uttar Dinajpur.
Uttar Dinajpur.
Lodge. My lord, in possession certificate.
Mouza Churamon,
that
lordship.
is
It's at
RS.
page 7.
Mouza Churamon.
Mouza Churamon, lordship.
That is
That's
this.
it.
LR plot
Page
number subsequently came into effect.
Yes. So
That
this,
one, my lord,
yes,
is not
it's
possible.
subsequent. No dispute on that. But here also the CS plot numbers.
Yes, and
Now, unless you say what is the corresponding CS plot numbers of that LR plot, how do you say that those plots were not involved?
My lord, it is correct.
Please ascertain that the learned advocate appearing for the petition. Yes, 14.
My lord, I am for the state reform.
Yes.
On allocation, Lordship, are pleased to hear out the matter, and the learned friend on the other side took time for filing report before Lordship, my lord. But my allegation is that, my lord, in front of my land, over the PWD land, my lord, they have encroached.
What is your instruction?
My lord, the plot and jail number, what have been stated is not a land of PWD. It's a private individual. I have annexed, my lord. My lord can get it schedule of the property in page 24. Page 20.
Please give me a minute.
My lord.
Yes.
Page
Show
20.
me your writ petition averments. What is the plot number adjacent to your property?
But they are actually page 24, my lord,
My lord,
23,
page
24.
24, if your lordship kindly come, the schedule of the property is described. Page 24.
Page 24.
My lord, got it?
Yes.
Schedule of my property.
Yes. His is 944 and 1062.
1062. But my lord, in front of that, my lord, my another plot is there, 1061.
Where have you
And-
stated that? Which paragraph have you stated?
Well, specifically, it has not stated, but my lord, it has been stated that
1061.
1061 is also my plot. Two plots are there, 1061 and 1062.
No, what is the plot in front of you, which you
What?
claim that it is a PWD road? Which plot?
My 1061 is my plot also, but I mentioned here only 1062. But it is also admitted position that they are saying that 1061 is also right land.
Yes.
And in front of my that right land, the PWD road has been obstructed. That is my allegation. That they are not denying that.
My lord, kindly come page.
They are not denying that whether there is
onwards.
any encroachment or obstruction over the PWD land or not.
4 onwards of my report. Page 4 onwards of my report. Page 2 is a report submitted by the revenue inspector before the block and land reform.
আমার কবে দিন না
Page 4 onwards is the
Yes. Page 4.
4 onwards. All details has been provided.
No. What is the plot in front of 1061 from the Moja map?
Yes, that will be clear. That is a PWD
1061.
land.
Where is 1061? But this is the difficulty. You have not mentioned that 1061. What can be done?
1061. What the my specific
Of this,
allegation?
what can be done?
Lordship, over my allegation is that in front of my land, two lands are there. Yes,
Front
that
of
is
your
that,
land, you will
yes,
not mention.
absolutely.
You
That
have
was
mentioned two plot numbers.
inadvertently,
You have said that-
inadvertently, that has not been mentioned particularly. But my specific allegation is that in front of my land,
make
and
a
they
fresh-
are not
make a
denying.
fresh representation. I give you liberty to
Lordship,
make a fresh
Lordship, that can be done.
representation. When vague allegations cannot be done.
But they are not denying that to the extent that
You have not made your case.
Lordship,
Where is the question of denial?
Lordship. No, they are not saying that the no encroachment was there over the public property or the public road. They are only saying they are avoiding the allegation, my lord, by way of saying that what.
Mr. Das, 1061 abuts a road.
Yes.
So, whether in front of 1061 there is any encroachment.
Well, specifically
Yes.
report is that there is no encroachment, it is private land.
To file a comprehensive representation, I direct them to consider.
Lordship.
Representations have to be specific. Ashun, the petitioner
mention one matter, Lordship. In spite of civil court
দাদা
order, Lordship,
দাদা
the private
দুটো দুটো
right
গেছে দুটো একটা রিপোর্ট
the land of the petitioner, Lordship, the petitioner communicated the civil court order to the private respondent.
Which group?
আমি জেরক্স করে দিয়ে
Group 9 আছে কি আমার?
আপনার ফোন নাম্বারটা
Group 9
এটা পেছনে যেটা
Lordship 65, we are for the appellant. We are being led by Mr. Piyush Chaturvedi, sir.
Yes, yes.
He's on his legs before for question number 18. Short.
Filed in the application. Yes. Yes.
Hello, we have also filed an application which is on board today.
Have an extra copy of
Yes,
the
we do.
photocopy of that application. You have served a copy upon them.
They have filed their opposition to my application. Well, this is my application.
So you are both of you are very prompt.
As your lordship knows, well, this has traveled to the Supreme Court twice. So
There's a direction from the Honorable Supreme Court. So I'm
not because of that, my lord, your lordship can understand.
Yes, Mr. Bose. This is your application.
Yes, my lord. Kindly take my application once.
Yes. And Mr. Banerjee, have you filed any application?
Yes. We have been served.
You have filed. You have been served.
Yes.
application not to carry on with the proceeding in the name of the current partners. We say that the partners, the reconstitution partners, the new partners, their name has not been intimated to the court. Leave to carry on with these current partners. That is the application.
The opposition.
Really. My lord, I have first given your lordship the application. Now, my lord,
So first you have given the opposition to the application.
where is the application? My lord.
Now I have got the application. So secondly, you have given. First you have given the opposition.
My lord.
So you want their case to be placed first.
My lord, my junior at least thought that way. I didn't.
So that was must have been the instruction, last minute instructions at the time of conference, Mr. Bose.
My lord, last night we were served with the application. That kind of made things easier for us.
Yes, Mr. Bose.
My lord, lordship will kindly take page 8 of the application.
Yes, page 8. Yes.
Your lordship will find this is a letter written by P.L. Malik and Company, the defendant.
Show me what is your prayer.
My prayer.
To record abatement.
Yes. No, record now. We say dismiss SAT for having abated. Yes. We say
abatement dismissal, it has to be only recorded as abated, Mr. Bose. I think that's the language.
If yes, CPC the
not any dismissal. Suit as abated, I think that's the provision.
Correct. That's why I have said having abated.
Not dismissal. You have said dismiss as abated. It should. That is what I have said. Recording abatement.
Yes.
Order 22, Rule 3, Sub-Rule 2.
Yes.
Within the time limited by no application is made under Sub-Rule 1, the suit shall abate. So the appeal shall abate.
Yes.
So not a question of dismissal as abated.
Our pleading is that the appeal has abated. Yes. No, I mean, yes, your lordship.
Dismissal as abated.
Correct.
So it should be record abatement.
My lord, kindly come to page 8 of the application.
Yes, page 8. Yes.
My lord, your lordship will find a notice written by the defendant present appellants. The
defendant present appellants.
No, this is the original defendant in my suit for eviction. And
where did I get the name?
I'll tell your lordship. On top left, page 8, your lordship will see left corner PL Malik and
No,
Co.
that's the letterhead.
Yes.
Who has signed.
That's I'm coming, my lord. Partners, kindly see, but what I wish to indicate to your lordship is
yes.
Partners, there are two names. B Malik, PN Malik.
Do you have a better copy of
Yes,
this?
my lord, the typed copy is in the next page, page 8A.
Mr. Banerjee, please check up the corrections, the typewritten. Yes.
It is there in the
All right. B.
compilation
Mullik,
as well.
B. Mullik, sometimes while typing, Mr. Bose, some errors may occur.
It
That
does,
is
it
why
does.
let him check so that.
It does.
Yes. So there are two names of two partners are there.
Yes.
Yes.
And Lordship will kindly make a note of the date of the letter, October 1995.
Yes. Yes.
The suit was instituted immediately thereafter. Now, my lord, your lordship will kindly come to
No, this is reply to your notice.
eviction notice, to my eviction notice.
Yes. Yes.
Then, my lord, it was signed, if your lordship will see the signature at page 16, 1/6.
So longish reply.
Yes. Fight between two solicitors, your lordship can well.
That's the reason.
Yes, that's the reason. Unfortunate, but what can be done?
16.
Yes. Page 16, 1/6.
16 is some copy of the cross-examination.
No, my lord. Page.
Oh, there are two page numbers. One.
Oh, I stand corrected. Yes,
one is
yes.
struck off and another is.
No, my lord, the one which has not been the 12.
I think 12.
12, my lord, my lord.
12. দুটো এসছে original টা এসছে? Mr. Bose, you take your copy. I've got my copy now.
Grateful.
Page 12.
Page 12.
Yes,
The letter
signed
was
by
signed by for P.L. Malik and Co. Your lordship will sign. There are two signatures are appearing.
two signatures.
It appears so.
Oh, yes. Yes, yes. There are two signatures.
Now, my lord, kindly take page 13, immediately the next page.
Yes.
This is the deposition of Poreshnath Mollik, one of the two partners.
PN is Poreshnath.
Poreshnath. PN is Poreshnath. This is one of the two partners.
Yes.
This is his deposition.
Yes.
It starts by I was attached as a article clerk with the plaintiff as PL Malik and Company, which is a solicitor firm. After passing in continued as assistant in the year 1944, I was then a partner, which is in the year 1995 of the plaintiff number 1 firm when the suit was filed. One B. Malik was another partner. Your lordship got that, my lord?
Yes.
One B. Malik was another partner who died during the pendency of the suit.
Yes.
So, my lord, he says was another partner means there were two partners at that relevant point of time. So the one partner dies during the pendency of the suit. Then, my lord, your lordship will kindly take page 19.
Yes.
PL Malik and Co. 21.
Page 19, yes.
Yes, my lord. That the fact that he has died. And then page, there's a nameplate. Anyway, my lord, since there is a admission by the surviving partner in his cross-examination, I need not show your lordship anything else. Now, my lord, your lordship will kindly take the opposition filed by them to my application.
Yes, where is the opposition? Yes.
My lord, death has not been disputed. Now, what has been said is that my lord, kindly have a look at, they annexed to their opposition a contempt application which had been taken out by us in the year 2018. And it is their case that in the contempt application, one of the grounds on which I alleged violation of an order, subsisting order in the second appeal, is that fresh persons were inducted as partners, and that could not have been done. So, Lord, they refer to, my lord, I'll just show your lordship 2 paragraphs from
basically a case of subletting.
Yes,
or sought to be made out by you.
Yes.
As a ground of contempt.
Well, my lord, now the situation has changed. Now we say that by operation of law, whether contempt, no contempt, subletting, whether the appeal survives or not. But this is the limited issue now before your lordship at present.
Where is the order passed? You are trying to show something.
No, my lord, the stand taken by them in their opposition to my application.
Is that in a contempt application you took this point?
Now, I took the point. I said that fresh persons have been inducted as partners. I have said that. And I have also said it appears that that amounts to an act of contempt. Now, my lord, what they say is that we were all along aware of the fact that the partnership firm has been reconstituted from time to time. Now, my lord, I had shown your lordship, if your lordship recollects, the stay application which was filed in connection with the second appeal. And if your lordship will kindly take that page, have you annexed that page here?
Thicker one or the thinner one?
Thicker one. Oh, well, you have not shown that. Why have you not annexed it here? Well, the thicker one, only one page from the thicker one. Well, this is the affidavit filed. Well, this is the affidavit page of the stay application in connection with the second appeal. Page 94. Here your lordship will find the thicker one. Yes. Pareshnath Mollik.
Yes.
So, well, when the second appeal was filed in the year 2005, Pareshnath Mollik, there does not appear to be any induction of anybody, and Pareshnath Mollik filed the appeal and the stay application. He affirmed the stay application in his individual capacity.
Yes.
So now, if your lordship will kindly take, what is the position of law in a situation where there are a partnership firm of two partners? I will kindly first take a judgment of the Supreme Court in the case of Muhammad Laikuddin, 2010, Volume 2, Supreme Court Cases, page 407. You should have told her the 5 judgments that I have given you all are standing and watching. How will she know which one? She kindly give Take out the next one. Take out the next one. Well, 2010, Volume 2, Supreme Court Cases, page 407. Take out the next one.
Yes.
My lord, kindly come to the first paragraph once. Just a brief fact, my lord, that will give us a better understanding of the proposition laid down. These 4 appeals are directed against the judgment and order dated 9th April 2002. My lord, the first paragraph, the first. It is actually not the first paragraph. The first paragraph is usually not numbered in the Supreme.
No, that's the first paragraph.
Yes.
The next is second.
Yes.
Yes.
These 4 appeals are directed against the judgment and order dated such and such in second appeal, such and such of the High Court, Andhra Pradesh, by which the High Court had partly allowed the appeals and modified the order of the first appellate court, which affirmed the order of the trial court, decreeing the suit for dissolution of partnership firm and other relief filed by the appellant who are appellants in CA such and such. Then, my lord, kindly take para 2 once. It may be mentioned that during the pendency of the suit, the original plaintiff died and her legal representatives were substituted as plaintiffs before the trial court. The original defendant also died before the filing of the first appeal, and his legal representatives were brought on record as appellant numbers 226 before the first appellate court. For the sake of convenience, the plaintiff and appellants and respondent. Now, my lord, kindly take paragraph 5 at page 411. By the judgment and order dated such and such, the civil court decreed the suit and passed the preliminary decree for dissolution and for rendition of accounts. The defendant was further directed to hand over the entire property and allied structure such and such. Trial court framed the following issue. Now, my lord, your lordship will kindly take para 6. After examining the oral and documentary evidence adduced by both the parties and after verifying the relevant partnership deed, court inter alia arrived at the following findings. I'll kindly see the finding. The partnership firm stood dissolved by the death of the original plaintiff on 17th May 1996. Then, my lord, skipping a few lines, thereafter your lordship will find there's a sentence towards the bottom of that page. It was ultimately held, the last two sentences, that there was deemed dissolution of the partnership firm with effect from 17th May 1996 due to the death of the original plaintiff. Then, my lord, kindly take para 8. Feeling aggrieved by the order of the senior civil judge, the respondents, the legal representative of the defendant preferred an appeal before the, my lord, City Civil Court, Hyderabad. The appellant also filed cross objection. Should be held that there was dissolution of the firm on account of mismanagement. The first appellate court, by an order of such and such, dismissed the appeal, confirmed the judgment. Then, para 9. The appellate court on the question of dissolution of the partnership firm concurred with the findings of the trial court, holding that since there were only two partners in the partnership firm and one of the partner died, there was no scope and possibility to continue the partnership firm. The appellate court further held that the respondent should not rely upon clause 24 of the partnership deed, which stipulated that after the expiry of 42 years, the land as well as the building with the fixtures, etc., would be vested with the original plaintiff. Then, my lord, kindly take paragraph 11. Aggrieved by the order of the first appellate court, the respondents took an appeal before the High Court of Andhra Pradesh. The High Court, by judgment and order, allowed the appeal in part and substantially modified the judgment.
27 you will be relying upon in support of your submission.
But I would like to show your lordship once para 15. I possibly will. 22 onwards.
22 onwards, the exact ratio is paragraph 27.
My lord. Then, my lord, if your lordship will see, there is one madras which has been followed. If your lordship will kindly see the quoted portion of the madras, at least for my convenience once.
Page.
My lord, immediately after paragraph 25.
Yes.
27 at the bottom of the page, in order to arrive at the conclusion that the partnership firm stood dissolved on account of the death of one of the partners, the High Court had rightly placed reliance on such and such, where the High Court held that the firm consisting of two partners on account of death of one of the partners.
Yes, I'm at that.
Yes, the partner dissolved. Then, my lord, kindly see the quoted portion which has been affirmed.
Separate. After that is the conclusion.
Yes, my lord, kindly see the quoted portion once.
Which part you will be relying upon?
Page 418.
Yes, yes.
The quoted portion, the middle portion. But let me just
even assuming.
No, on this
normally dissolves. It starts.
Even assuming that there was such an agreement. Actually, there was an agreement saying that the legal heirs will become automatically partners.
Yes.
In the partnership consisting of two partners, on the death of one of them, the partnership automatically comes to an end, and there is no partnership which survives and into which a third party can be introduced. Hence, on the death of S, the original partnership was dissolved. The subsequent taking in of the SSE as a partner was only as a result of the entering into a new partnership between R and the SSE. The partnership was not a matter of heritable status, but purely one of contract. Then, in light of the aforementioned case, it is clear that when there are only two partners constituting the partnership firm, on the death of one of them, the firm is deemed to have dissolved despite the existence of a clause which says otherwise. The partnership is a contract between the partners. There cannot be a contract unilaterally without the acceptance of the other partner. Then, my lord, para 28 of your lordship.
Para?
28.
Yes.
The appellants, the legal representatives of the original plaintiff since deceased, were not at all interested in continuing with the firm or in considering the legal firm. They cannot be asked to continue the firm as there is no legal obligation upon them to do so. In the partner is a matter of heritable status, but purely of a contract, which also clear from the definition of the partnership under section 4. Therefore, the trial court was justified in holding that the firm dissolved by virtue of the death of one of the partners, and the first appellate court as well as the high court have taken a correct view.
There are two partners, one died automatically dissolves. Subsequent taking of any partners cannot revive that old partners.
Yes. Then, my lord, this, if your lordship now kindly take 2019 10 Supreme Court cases, page 329.
For the same proposition.
No, my lord, this is a little advanced proposition.
Yes.
2019 10 SCC, 10 Supreme Court cases, 329. SP Mishra versus Muhammad Laikuddin. Yes, madam, 329. My lord, if your lordship kindly comes to para 16 once.
You have given me.
Huh?
Yes, yes.
Court officer change. No, no,
2019 10 SCC.
Yes. তোমায় দেবো? দাও ওকে দাও। Para 16. In the case on hand, as much as there were only two partners, the partnership itself stands dissolved in view of the death of a partner. It is true that as per the deed of partnership, the partners have agreed in the event of death of either party, their respective legal representatives shall automatically become partners in the partnership firm, and they shall continue to act as partners of the firm till the venture envisaged under the said partnership is completed, and such legal representative who become partners shall become such and such responsibility of the deceased partner. At this stage, it is to be noticed that once the partnership comes to an end by virtue of the death of one of the partners, there will not be any partnership existing in which legal representative of such and such could be taken in. The judgment and decree obtained by such and such against such and such in pursuance to the partnership deed cannot bind the legal representative of such and such, as the decree is not executable against them. Then such and such, then my lord, skipping a few lines, if your lordship will kindly take placitum G. When the partnership stands dissolved by operation of law under 42C of the Partnership Act, the question of execution in pursuance of the decree does not arise. There cannot be any contract unity without acceptance of an agreement by the legal heirs of the deceased partner. If there are any clauses in the agreement entered into between the original partners against the third party, such clauses will not bind them. Such of the clauses in the partnership deed which runs contrary to the provisions of the Partnership Act are void and unenforceable. Such clauses are also opposed to public policy. Now, my lord, here, pausing for a moment, your lordship will see their application, the next application, where they say that they seek a direction to allow them to continue with the appeal. That's the effective relief that they seek in their application. My lord, the original partnership deed, nothing. It's a bare-bodied application, no documents before the court. So today there is nothing before the court. Even, my lord, what was the clause in the original partnership? My lord, admittedly, after the death of Balodev, during the pendency of the suit, that is, my lord, prior to the decree which was passed, nobody was brought as the legal heir of the Balodev. No, whether that would have been contrary to or opposed to public policy, that is another situation. But the fact remains, nobody was brought in.
Yes.
Nobody was impleaded as legal representative of Bolodev. Matlab, good, bad, indifferent, PN Malik continued in his individual capacity
After the death of the
after
other
the
partner.
death of the other partners, defended the suit, suffered the decree, then suffered the first appeal court's order, and thereafter filed the second appeal also in his individual capacity.
Yes.
Now, your lordship will take a situation like this arose in 65 Supreme Court. This is, my lord, 65 Supreme Court, online Supreme Court 183. It is also reported in 57 ITR, page 510. Yeah, give it to them now if you have an extra copy.
Yes.
Now, my lord, kindly take paragraph 6 once.
Yes.
The question is whether on the death of Nandlal, his heirs, the members of his branch of the family, automatically became the partners of the said firm. The answer to the question turns on section 42 of the Indian Partnership Act. Then, my lord, kindly take, my lord, the quoted portion, kindly take the end of the quoted portion, which starts from the next page. Converting the negative into positive under section 31 of the Partnership Act. If there was a contract between the partners, a person other than the partners could be introduced as a partner of the firm without the consent of all the existing partners. A combined reading of section 42 and 31 of the Partnership Act, according to the Learned Counsel, would lead to the only conclusion that two partners of a firm could by agreement induct a third party into the partnership after the death of one of them. Now, my lord, kindly see the answer. There is a fallacy in this argument. Partnership under section 4 of the Partnership Act is the relationship between the persons who have agreed to share the profits of a business carried on by all or any one of them acting for all. Section 5 of the Act says that the relationship of partnership arises from contract and not from status. The fundamental principle of partnership, therefore, is that the relationship of partnership arises out of a contract and not out of status. To accept the argument of the Learned Counsel is to negative the basic principle of law of partnership. Section 42 can be interpreted without doing violence either to the language used or to the said basic principle. 42C of the Partnership Act can appropriately be applied to a partnership where there are more than two partners.
Yes.
If one of them dies, the firm is dissolved. But if there is a contract to the contrary, the surviving partners will continue the firm. Pausing for a, so there has to be more than one to apply that. The surviving partners will continue.
There are two, one dies, automatically dissolved.
And any further act would lead to a fresh partnership. If one of them dies, the firm is dissolved, but if there is a contract to the contrary, the surviving partners will continue. On the other hand, if one of the two partners of the firm dies, the firm automatically comes to an end, and thereafter there is no partnership of a third party to be introduced therein, and therefore there is no scope for applying clause C of section 42 to such a situation. It may be that pursuant to the wishes or the directions of the deceased partner, the surviving partner may enter into a new partnership with the heir of the deceased partner, but that would constitute a new partnership. In this light, section 31 of the Partnership Act falls in line with section 42 thereof. That section only recognizes the validity of a contract between the partners to introduce a third party without the consent of all the existing partners. It presupposes the subsistence of a partnership. It does not apply to a partnership of two partners which is dissolved by the death of one of them. For in that event,
Partnership has to be subsisting as on the date for taking a new partner.
Correct.
Dissolution ends that. That's the sum and substance of this.
yes, yes. Then, my lord, the conflict of judicial decisions are recorded from paragraph 8. And then your lordship will see all the views are considered. And thereafter at paragraph, the views of Nagpur and Calcutta was, if your lordship will kindly take page, the print page 6, on top on the corner, your lordship will see the page number, the second last page of possibly of the judgment, 6. And kindly see, before para 9 begins, there is a sentence before paragraph 9. We accept, just immediately
Rather than Madras accepted, Nagpur, Calcutta rejected.
rejected. Now, my lord,
Yes.
there is one more Madras. There's a single bench Madras.
After this,
Yes,
Supreme
of
Court,
course. No, I, that's why I did not show it to you.
don't multiply on
No,
the
no, no,
same
I will
group.
not. I will not. I
Yes.
will not. Now I'll give you lordship a judgment on abatement.
Yes.
Well, 2001, volume 5, Supreme Court cases, page 570.
Yes.
Well, kindly come to paragraph, the first paragraph first.
Yes.
This appeal is directed against the order passed by the learned single judge of Rajasthan High Court in civil division. One Lakshmi Lal filed the suit for specific performance. So Lakshmi Lal was the plaintiff against Radhu Lal. So Radhu was the defendant. The suit was dismissed by the trial court. The plaintiff Lakshmi filed an appeal and the appellate court allowed and decreed the suit. Aggrieved defendant Radhu preferred a second appeal in the High Court against the decree granting specific performance. During the pendency of the second appeal, the plaintiff Lakshmi died and his legal representatives were brought on record as respondents in the second appeal. It is admitted by the parties that while the second appeal was pending, Radhu died in 1990, and this fact was not brought to the notice of the court and the appeal was dismissed. The legal heirs of the deceased Radulal did not take any steps to have the judgment in the second appeal set aside. The legal representative of the decree holder Lakshmi filed execution. Then, my lord, it continued. The subordinate declined. Then, my lord, kindly take para 2. The order of the subordinate judge challenged before the High Court. And the learned single judge of the High Court held that the decree passed by the second appellate court was a nullity as it had been passed against a dead person, and this decree had merged with the decree passed by the first appellate court. Then, my lord, the issue was, if your lordship will kindly take.
Issue was at paragraph 7.
6. Yes, well, if your lordship takes 6 months, yes, of course. 6 and 7.
Framed at paragraph 7, last sentence.
Yes. Therefore, the question that requires to be considered is that when there was an abatement of the second appeal, could there be a merger of the same? No, so the abatement of the second appeal situation was also considered. If that is there at paragraph 6, if your lordship will take. The various provisions of Order 22 explain the consequence, para 6, of the death of the parties in a civil litigation. If one of the plaintiff dies, and if the cause of action survives, his legal representative have got the right to come on record and to continue with the proceeding. If the sole plaintiff dies and if the legal representatives are not brought on record, the suit will abate under Rule 9. specifically prohibits the filing of a fresh suit on the same. The only remedy available to legal representatives is to get themselves impleaded and continue the proceeding if the suit is already not abated, such and such. In the instant case that deceased Radulal, the second appellant, died in 1990 and his death was not brought to the notice of the court, and the learned single judge disposed of the appeal on merits by dismissing the second appeal. As the judgment in the second appeal was passed without the knowledge of the appellant had died, the same being a judgment.
According to you, the first appellate court's decree had become final in view of the observations made in paragraph 14 of this judgment.
Yes.
That's the submission.
And my lord, P.N. Mullik having died, my lord.
If the second appeal abates, so it's only the operative judgment of the first appellate court.
Yes, that is that is the second situation. But the first situation is that after the death of P.N. Mullik and no.
First is whether it had abated. Second is effect of abatement.
First,
Anything more, Mr. Bose?
No, we are on this first situation, so far as this is concerned.
Yes, because second situation has not yet arrived.
No, that will depend upon what your lordship holds so far as abatement is concerned.
Anything more?
Well, there is a judgment of our court which went up in Supreme Court. I am sure, well, your lordship is well aware of that. We all had some point of appeared in that matter, my lord. That Waldorf restaurant judgment. Well, 2003 6 Supreme Court cases, page 423. Well, here was a situation, my lord, your lordship will see P.N. Mullik. P.N. Mullik is a trade name. Baladev Mullik and P.N. Mullik carried on business in their trade name P.N. Mullik and Co. So, my lord, apropos this, my lord, here your lordship recollects, Waldorf Restaurant was a partnership firm. And Waldorf was one of the subtenants. There was a suit against the original tenant. There was a settlement which eventually reached the Supreme Court. Then that got settled. And at that point of time, the tenant had disclosed that there were 3 subtenants. So 3 separate suits came to be filed, and one of such suit was against Waldorf. Waldorf was subtenant. Then, my lord, if your lordship will kindly take once para 31.
Yes. Yes.
Similar situation, there are 2 partners. So Waldorf Restaurant is merely a trade name. It is not a legal person and has no existence independent of the proprietor who initially carried on business in that trade name in the suit premises as subtenant, and later on by joining as partner of the firm registered in the name of the trade name. The present firm comprises of totally new partners and not disputed fact that such and such, the tenant, Allenbury and Company, has sublet the suit premises to Wing Chong Wong as sole proprietor of Waldorf Restaurant. Now, my lord, your lordship will kindly take. My lord, section 14 situation is considered. The interest. My lord, if your lordship will kindly take once the Partnership Act and kindly consider section 14. Give one to the judge.
Yes.
Subject to the contract between the partners, the property of the firm includes all the property and rights and interest in property originally brought into the stock of the firm or acquired by the purchase or otherwise by or on behalf of the firm or for the purpose and in course of the business of the firm, and includes also the goodwill of the business. So, the rights and interest in the property.
Yes.
Now, my lord, apropos this, my lord, section 35, where section 14 of the Partnership Act was considered.
Paragraph 35.
Yes, my lord.
Yes.
It
And
says,
paragraph 35.
yes, my lord. Now, my lord, your lordship will kindly take.
What do you want to say from paragraph 35?
Now, my lord, kindly take para 36. No, my lord, kindly allow me to place 35. Otherwise, it will not. It says under section 14, in the absence of an agreement to the contrary, property exclusively belonging to a person or his entering into a partnership with others does not become a property of the partnership merely because it is used for the business of the partnership. Such property will become property of the partnership only if there is an agreement, express or implied, that the property was under the agreement of the partnership to be treated as a property of the partnership. When I'm pausing here for a moment, your lordship will see the plain case. All along, my lord, my tenant was the firm. So I have always recognized the firm as the tenant. So, my lord, once this is an interest that the firm had, there is nothing on record to say or would to show otherwise that it was the asset of any one of the partners. There is nothing to that extent. They accept the fact that the partnership firm was the tenant. So the interest in the property was that of the firm, which stood dissolved by operation of law upon the death of one of the partners. Now, my lord, apropos this, my lord, kindly take para 36 once.
Yes.
The reasoning adopted by the division bench is erroneous. That subtenancy is created both for the proprietary concern and the partnership firm, merely because the trade name in which the business was continued remains the same, Waldorf Restaurant. My lord, here, pausing here, my lord, what had happened is, my lord, it was a sole proprietorship. It got converted into a partnership. The reasoning adopted by the division bench, which has been supported by the learned counsel appearing on behalf of the firm, is obviously misconceived in law and proceeded upon misdirection of facts. As we have stated above, Waldorf Restaurant is merely a trade name. It is only a legal entity dependent on proprietor of the firm carrying on the business. Then, my lord, it continues. But there was a issue of direct tenancy. My lord, kindly take once para 37.
Yes.
37. May I please 37, my lord?
Paragraph 37.
37. Yeah. In the aforesaid situation, the claim for status of direct tenant and protection under the Act of 1950 could, if at all, have been claimed only by Wong as the sole proprietor of the business concerned by substantiating the necessary conditions precedent, including the point of time when he became one such, in the background of the notice of surrender of the tenancy by the tenant. After Wong had walked out of the tenanted premises, ceasing to have any concern, connecting, or interest in the firm, and left India, the present partners of the firm who are in occupation of the business premises have no right in present time to resist their dispossession under the decree obtained against the tenant. Along with the tenant who has already surrendered the tenancy and vacated the leased premises, and the subtenant having already lost possession of the leased premises, the present firm with its new partners who claim to be in occupation through the subtenant have no right to resist the execution of the decree. So, my lord, their contention that the firm has been reconstituted And I continue in my respectful submission, my lord, they have no right to contend that this same firm is continuing. This firm has, by operation of law, has dissolved. So, my lord, they have no, my lord, the right to sue does not survive. Upon the death of P.N. Malik, the right to sue came to an end, ceased. That the present persons who claim to be the partners, whether they could have been partners, that's a different issue. They don't have a right to, my lords, the right to sue does not survive. And there is nothing on record. And my lord, it is also one of our contention that since there is the original partnership deed, subsequent reconciliation, nothing is on record. That is important. These are my respectful submissions so far as abatement is concerned.
Yes, Mr. Chaturvedi. নাহলে একটা আনিয়ে নিন। Yes, yes, Mr. Chaturvedi. এটা ওনাদের বই।
The application rests on two presumptions. The first presumption is that at all point of time, there were only two partners in the firm. So when one dies, the
Partnership firm dissolves.
The firm dissolves. So that is the first presumption. The second presumption is that Order 22 applies. Now, I put a question to myself, Lord, in the evidence of DW1, P.N. Mullik, Lord, it is stated that another partner, the word uses another partner, B. Mullik has died. That was during the pendency of the suit.
So initially there were P.N. Mullik and B. Mullik.
Initially there were, initially, Milord, if we go to the initial part, there were
no, not the initial at this time when the suit was filed.
Yes.
Or just prior to the suit being filed.
Prior to
or we can take it at the time of issuance of the notice of eviction. We can start from that stage.
Yes. At that stage, in 1995, there were two partners. Then there was a reconstitution during the pendency of the suit, bringing in a third partner. Then in 2000, one partner dies.
So according to you, there were initially two, reconstitution by two to make it three. And from three, out of three, one died.
One died. Now, if I rely on the story of the respondents that there were only two partners during the pendency of the suit. If one died, they did not take any steps under Order 22. What
Mr. Chaturvedi, it does not require because abatement is automatic.
No,
abatement is automatic.
Suit. One died during the pendency of the suit.
Is it so?
Kindly, I shall come.
One out of the two, one died. I showed that deposition. He says that both of them has died. No, I have given the deposition is a part of my application itself.
Please, Mr. Chaturvedi, please, at a kagos din to.
I shall come.
Yes, please give me the dates.
But kindly, Milord, kindly comes to page 46 of my affidavit in opposition.
এই affidavit in opposition টা কোনটা এটা? আচ্ছা, এটা মিস্টার বোসকে ফেরত Please keep it when required. I will. Very. Atani and Inuta. Yes.
Milord, kindly, Milord takes up my affidavit in opposition. Milord, kindly comes to page 46.
46.
My lord.
2000. So this is the same evidence, I think, Mr. Bose.
Yes.
Relied
Same.
upon.
Yes. Now, my lord, kindly sees, my lord, this is my lord P.N. Mullik.
P.N. Mullik.
And the firm is P.L. Mullik, my lord,
Yes,
Pannalal Mullik.
that's the trade name.
Pannalal
According
Mullik.
to Mr. Bose.
I come to that. So P.L. Mullik, blood, it is a about century-old firm, and it got reconstituted from time to time. Now, when the plaintiffs claim to have come into the gained title or right in respect of the property, blood, many reconstitutions had already occurred. During the pendency of the suit, reconstitution occurred and death also occurred. Now, this reconstitution, if the plaintiffs don't accept that a reconstitution during the pendency of the suit was in fact a fresh subletting, they have made out that case and they have filed a contempt application. I shall come to it. So, if they rely on their own story, there were two partners when the notice to eviction was issued or when the suit was filed, and they do not take any notice of any subsequent reconstitutions.
And one of them died during the pendency of the suit.
Yes, this is what I am showing. Now, kindly sees.
Yes.
The fourth line.
Yes.
At page 46, I was then a partner.
After passing in.
Yes, after passing in, I continued.
It should be I.
I
continued.
As an assistant in 1944, I was then a partner, which is in the year 1995. Of the plaintiff
When
number.
the suit was filed.
Yes.
So we can take it at this stage.
Yes.
So.
And one B. Mullik was another partner.
Who died during the pendency of the suit.
Yes. And this lot is said, kindly sees the date at next page. 8th April 2002.
Where is?
At the bottom, page 47. The date of the deposition.
Yes. So it was said as on this date. And when did B. Mullik die?
The date has come as 2000.
It must be in between the filing of the suit and 8th of April 2002.
There is averment by both the parties that he died in 2000. The exact date is known to neither of us. I shall show that it is 2000. So in 2000, or if I say that any time before 8th April 2002, one of the partners had died, the firm automatically dissolved.
So according to you, the suit abated.
The suit abated, if I believe their story. Now, what do they say? They say that the partnership may have ended on the death of one of the partners, and I do not recognize any reconstitution. So the firm, my tenant, it finally got dissolved when the second partner also left for heavenly abode. That is the story.
According to you, the death of the second partner is not at all relevant.
Not,
because the firm stood dissolved.
I can stand up on the Shohid Miran and say that I am alone a partner of a firm. No one would believe me because law does not recognize it. It has to be law provides for 2 or more than 2 persons.
At least 2.
At least 2. ওই অ্যাডমিশনটা দেখো 2000 দেখে নিছে ওরা অ্যাডমিট করেছে 2000 তোমার ট্রায়াল কোর্টের জাজমেন্টে দেখি দাও now my lord kindly sees this factum of reconstitution. My lord, the respondents may deny today that they don't recognize this
any reconstitution after the filing of the suit.
Yes, they may deny today. Let us see.
It was not before the court.
Yes. Now, this denial kindly sees whether they have acquiesced this. To that, I would first say, could they have acquiesced this? The answer to that is yes. But section 42, subsection C of the Partnership Act, Lord, it says on the death of the partner, that the firm would dissolve.
This is, however, qualified with the commencing line, subject, however, to the contract, to any contract to the contrary. So the moment the respondents, they acquiesced the reconstitutions, there is a presumption that they are aware that there is a contract to the contrary, in exercise whereof the firm is being reconstituted.
Mr. Bose, can you give the partnership act?
Lord, yes, yes. Lord, kindly take my book when my lord is hearing.
It's a different thing. Something has been stated, Mr.
My lord?
No, I'm asking Mr. Chaturvedi some different wordings in his
Possibly,
book of 42C.
Possibly.
Yes. Yes.
Now, my lord, kindly, my lord, see, my lord, section 42, subsection C.
Yes.
Lord, kindly sees that the mode of, my lord, dissolution, my lord, provided for in A, B, C, and D by happening of these contingencies, in our case, my lord, C would be relevant, is qualified by the commencing lines, subject to a contract between the partners, a firm is dissolved. So, these contingencies are subjective to, if there is anything to the contrary, then they do not apply.
Chaturvedi, there, 42 says,
my lord,
subject to contract between the partners, a firm is dissolved. C says, by the death of, next is very important, a partner.
Yes.
So, if there is a partnership, let us suppose of 5 partners.
Yes.
Now, nothing is provided as to the continuance of the partnership after the, because usually we will be finding in a partnership deed, it says if any one of the partners dies, so heirs or other things, induction may be there. Now, let us take a case where in the partnership deed, it's silent about what would happen after the death of a partner.
Then there is no contract subject to the contract.
Yes, if there is, in those cases,
this
if
will
the
apply.
contract does not apply, if any one of the partner dies, firm stands dissolved. But if the partnership agreement says yes, no, these heirs, remaining partners may continue, or the heirs will come subject to the consent, then it covers within the expression subject to the contract.
I'm grateful. I'm grateful. This is the point that I want to make. So, C is qualified, or A, B, C, D contingencies are qualified by, in the event if there is a contract, then A, B, C, D do not apply. Do not apply. I say that there was a contract which provided for the firm to continue notwithstanding the death of any of the partners. And this fact,
Mr. Chaturvedi, there is a distinction between, let us assume 5 partners.
Yes.
And one of them dies, 4 partners can continue if there is a provision to the contrary in the partnership deed. Now, let us take one by one from 5, 4, 3, 2, till that time it can continue.
Yes.
Now, what happens
when
if the
remain, one die?
Yes. That's the contention of Mr. Bose. If 2 remains,
what happens?
1 dies, then it's not,
then
because
contract or no
concept
contract
of partnership is
non-existent.
Yes. That's the submission that there were 2, 1 died, so the partnership dissolved.
My lord. So, my lord, again, my lord, I get back to from where I started, my lord, to continue with this. Mr. Bose's contention is that at the time of institution of the suit, there were 2 partners. And these 2 partners, they continued. B. Mollik died in 2000, but the other partner remained alive in 2021. The moment he died, abatement took place. That is the case made out in, and recourse has been taken, my lord, to order 22. To that, my lord, my retort is that if the story of the respondent plaintiff is to be believed, then the suit abated in the year 2000.
Upon the death of B. Mollik.
Upon the death of B. Mollik, this factum is an undisputed fact, blood, which has even been recorded in the orders passed by both the courts
So
below.
according to you, the decrees of
Nullity.
the trial court was in ignorance of a death of a party and decree passed against
One of the dead persons. Now, blood, what is my specific case? Blood, this is, my lord, I demolish his case. What is my specific case? My specific case is, in 1995, it is true that there were two partners, blood, P.N. Mollik and B. Mollik. Now, before 2000, one Mr. Taposh Hajra was inducted.
So before death of B.
Mollik, one Taposh Hajra was inducted as a partner. The partnership firm was reconstituted. Then in 2000, one of the partners died, leaving behind two partners. Then there has been further reconstitutions. I say that today, without showing any document of reconstitutions, can I assert before this court that reconstitution is a fact which was to their knowledge? My submission to that is that it is not only to their knowledge, but they have acquiesced this fact. Not how? Not kindly, Milord, comes to not page 20 of my affidavit in opposition.
Page 20.
Page 20.
Yes.
Lord, kindly sees, Lord, this is Lord a contempt application.
Yes.
Lord, before Lord moving forward, Lord, I only indicate to my Lord that during the pendency of the second appeal, an order, Lord, of status quo as regards, Lord, the nature, character, and position was passed, Lord, by at the time of admission and then confirmed by a learned single judge. When they saw that the reconstitution has happened and they see new faces in the tenanted premises, in the tenanted portions, they say that there has been a violation of the court's order. And Lord, kindly come to page 21. Deliberate, willful, contumacious disobedience and violation of the order dated 8th September 2010, passed by Honorable Justice so-and-so in so-and-so.
Was the status quo order?
Lord, yes.
8th September was the status quo order.
My Lord.
Yes.
And then, Lord, kindly sees, Lord, the violations.
Inducting two new partners.
By illegally raising, I am not concerned.
So you are on 5.
Lord, I am on 4.
4 and 5 in becoming partners and inducting two new partners.
Yes. And then Lord kindly comes to page 25.
Yes.
Lord kindly sees PL Mollik and Company, a partnership firm.
Yes.
Kindly sees number 2. Lord Dibanath De, partner of PN Mollik.
Yes.
Lord kindly, Lord, kindly hold on, Lord, with a mark to this page, and kindly sees, Lord, who has affirmed the affidavit at page 45. At page কত বলো কি 45 Lord, at page 19.
19. 19 of
Lord, the same, Lord, my affidavit, which I am.
Oh, yes, yes. That same person.
Same person. Same person has affirmed. So, the reconstitution has been acquiesced by them in as far back as Lord 2014.
This is
contempt application CPAN
of 2014.
2014.
Yes.
And কি বলতে চাইছো?
Yes, yes.
Now, Lord kindly sees Below the next page, page 26. Below kindly see below serial number 3, addressee number 3. He has been added as a contemner. He is also a partner. He was one of the partners on subsequent reconstitutions.
Yes.
He's no more with us. Before his death, he died, left us at a very young age.
Yes.
Before his demise, the firm was further reconstituted. Now, kindly see, these persons who have become the partners of the defendant firm, have been impleaded as partners
by them.
By them. And then kindly see, serial number 5.
Was the other partner who was living at that point of time?
Yes, kindly
out of
yes.
Yes.
Now, kindly see serial number 5.
He was the sole surviving out of those two.
Yes.
Initial two.
Now, he retired in 2013.
Oh, he retired.
In 2013. And this fact was to their knowledge. As much as the induction by reconstitution of the contemner, alleged contemner number 2 and 3 are concerned, this fact that 5 has retired is also to their knowledge. And hence, kindly see, P. N. Mollik is not referred to as a partner here.
Yes.
To sum up, whatever I am saying is that if the reconstitution was a fact, the reconstitution is a question of fact. If the fact of reconstitution was to their knowledge and they acquiesced it, today can they fall back upon the story of P. N. Mollik, the sole surviving partner of P. L. Mollik, dying in 2021. We were not aware, but the appeal has abated. When did it abate? It abated in 2021, when the sole surviving partner of the firm died. I fail to understand this analogy. As to how can there be a sole surviving partner? If that be so, that there were only 2 partners, then the suit abated. Do I come back?
Yes, come back at 2 p.m. And what was the order passed on this?
It is pending.
Contempt application is also pending. Oh, Mr. Bose wanted to show, you wanted to show this application. You said that some contempt application and order has been passed.
No, I said that in their opposition, the only document appended to their opposition is the contempt application. Yes.
But no orders have been passed on this.
Since
orders have been
order has been passed.
We will check, and they have disclosed. We were completely unaware of this fact.
Yes, yes, Mr. Chaturvedi. Yes.
May I only complete this part of it,
Yes, yes.
Now, kindly see page 35.
Yes.
Kindly see paragraph 7.
7 or 17?
Paragraph 7 or 17?
17. I'm so sorry.
Yes, yes.
Your petitioner has further come to know recently that after the order dated 8 September 2010 was passed by the Honorable Justice so-and-so, directing the parties to maintain status quo as on the date with regard to nature, character, and possession of the suit property, the contemner so-and-so, one of the partners of so-and-so, devised a fraudulent mode of transfer of the subject tenancy by inducting a so-and-so into the partnership firm, being the contemner, so that the order of status quo could be circumvented. So, this allegation has twofold aspects. One, an admission with regard to admission of new partners and the reconstitution. Second, an allegation that this tantamounts to further subletting.
So according to you, they cannot take advantage of both. That will be your submission.
Milord,
If
we
they
all
want to
use
take advantage of the ground of subletting, then they have to accept this.
we all use knives at home. It cuts only one way. If Mr. Bose wants to have a knife which cuts both ways, then it is difficult. Kindly now see, Milord, the next page, page 36.
Yes.
The contemners respondents number 2 and 3 became partners of the respondent number 1. How much more categorical, Milord, this could be that they had knowledge that there has been reconstitution and new partners have come in. And this is being said, Milord, at the risk of repetition, I say, in 2014, when, Milord, at least one of the, in their own words, original partner was still alive. And to whom they do not refer in the petition as partner because they are aware that he has retired. 2 and 3 as referred to as partners of the firm, 5 is not.
Who was originally one of those
Yes.
surviving
Yes.
out of those
Yes.
two?
And whose death, with deepest of respect, I may say, they were waiting to call it that the firm has resolved.
No, I could not follow. Yes.
Whose death they were waiting to call that the firm has now dissolved. Now, Milord, kindly see, Milord, this act. I'm sorry.
Yes, yes, yes.
Milord, Milord, kindly see, Milord, page 38.
Yes.
Guilty of willful disobedience of order of status quo passed by this court by becoming partners of the firm.
Which point?
Milord, the page 38.
Oh, yes, yes. Point number 5.
Yes.
Point number 5, yes.
Milord, it is a continuation of point number 4.
No, here ground number 5.
Milord, kindly see, Milord, page 37.
And each of them, yes, guilty of by becoming, yes, 4 and 5.
4 and 5. And then, Milord, page 39.
Grounds can it be admission, Mr.
I am only saying that I derive a corroborative value of whatever I have shown previously, read with paragraph 23.
Paragraph 39 is the prayer. So
no,
again,
23, paragraph 23 on page 39.
Paragraph 23. Oh,
The
is a partnership firm.
number 1 is a partnership firm of which the contemners number 2 and 3 are partners. But this is a paragraph. But now kindly, Milord, comes to and then contemner number 4 is illegally occupying a cubicle, saying nothing about the contemner number 5.
And paragraph 23 is true to his knowledge.
I was showing that, Milord, only that much. We can pause here, Milord, for a moment. Now, Milord, only one submission. Despite, Milord, hearing all this, if, Milord, my landed friend wants to press the issue of abatement, then, Milord, all of us, Milord, will have to, Milord, spend some more time and waste my Lord's judicial time. Or else, Milord, I was respectfully beseeching your Lordships, but subject to my Lord's kind sanction, if we can, Milord, argue the issue of abatement as well as a substantial question of law together, and Milord, invite a judgment from my Lord on both the issues, because one is a preliminary objection with regard to the maintainability, other is a substantial question of law. So we are ultimately, Milord, arguing before my Lord on questions of law. He has cited judgments. Now, in piecemeal, I, Milord, cite judgments in reply thereto. I have given my Lord the facts. There are 2 stories. He banks on order 22. I am banking on 42 subsection 3, and I shall show, Milord, the provisions of CPC which will apply to me. So if we come prepared, Milord, to argue on the appeal, including...
I think Mr. Bose will not agree to that.
No, my instructions are not to agree. As your Lordship knows, these are matters which
No.
I am just...
Maybe because Mr. Chaturvedi, this issue has to be addressed first, because whether if the appeal abates, and then no use hearing it on merits. So this issue has to be decided. And yes, if both of you agree, yes, everything, I think Mr. Bose cannot agree to that.
No.
That's why, Milord, I said subject to my Lord's kind sanction.
Mr. Chaturvedi, this application has to be considering the nature of the application. So these are to be heard, both your applications.
Correct.
Mr. Bose's application as well as your applications, because this goes to the root of the jurisdiction to hear out the appeal on its merit.
I can agree to Mr. Chaturvedi's suggestion if both these two applications, one by him and one by us, can be heard together and discussed.
That is by default.
Together
The
has
two
to be heard.
applications. That's what I say. I can agree to that.
No, that has to be heard,
Correct,
Mr. Bose, because when an application, both these applications have been filed.
Yes.
Now,
Of course.
the
Of course.
other way
Yes,
around,
yes, we
if
understand.
Mr. Chaturvedi's application is allowed,
Correct.
then your
My
application
fails.
has to be rejected.
My allowed that.
Practically, Mr.
Correct.
Chaturvedi's
Absolutely.
application is to be heard fast.
Lord, we have learned that when
Because your application is only to bring to the notice of the court that for this fact, appeal has abated.
Absolutely.
Now, if that is automatic with regard to that, then it's after all, if
Absolutely.
Mr. Chaturvedi succeeds on his application, then this appeal remains.
Absolutely.
Otherwise, it goes.
My lord.
So,
My lord.
we come at
two. This is whose book? Mr. Chaturvedi's book.
Yes.
দিয়েছেন কি একটা?
kindly
Number 65.
Yes. Yes. Yes.
And pass it over for a few minutes, then Mr. Chaturvedi.
Suppose it's continuing. Where is Mr. Chaturvedi? He was making submissions. Please start. Anyone of you, please start. So continue. I cannot pass it over. You are in this matter, Mr. Bose.
Yes, Milord, but I could not follow Milord what manner.
All right, he was there. Yes.
I was in code number 4.
The Lordship kindly takes up the can 11, my lord, filed by the page number, paragraph 14, page 5. Can 11.
Paragraph 14.
Page 5.
Yes.
At the time of institution of the suit, the defendant appellant firm.
No, paragraph 14 of what?
The can 11, my lord, the application of Mr. Bose.
Can 11?
Yes.
The can 11 to the.
Yes, sir.
Yes.
Paragraph 14.
Yes.
At the time of institution of the suit, the defendant appellant firm admittedly had two partners with their averment, my lord.
Can 11?
Yes.
Paragraph
14, page 5.
14. At the time of institution, yes.
The defendant appellant firm admittedly had two partners. One of such partner having died during the pendency of the suit. This
Yes.
basic admission, my lord.
Yes.
And the partnership firm dissolved by operation of law. My lord, in the suit, my lord, PL Mollik and Company, the partnership firm is only one entity, my lord. And the partners have not been made party by name.
Yes.
And all such from the list of evidence, my lord, supplied by my learned friends, my lord, which is at page PW1 also admitted
Yes.
that is
Yes, Mr. Chaturvedi.
I'm sorry, Milord. We're navigating the way to my lord's court from bar association number room 6 is a little difficult now.
Why?
Because of the ongoing elections.
Election to Friday.
No, cholse to.
Election started.
Yes, yes.
This is the High Court Club.
High Court Club.
Oh, High Court Club. Yes.
No, my lord, I was showing from the contempt.
Stop with those paragraphs of the contempt application.
My lord. Now, my lord, kindly sees that my object of showing the contempt application is their knowledge and their acquiescence
to that fact
to
of
the
reconstitution of partnership.
Of reconstitution of partnership on one hand, and apropos the retirement of Mr. P.N. Mollik, who they say has died in 2021, and that is the cause of abatement. So the partner whom they say his death is a cause of abatement I say that he has retired. He has retired, and before his retirement, a reconstitution has occurred, which has been recognized by you.
Yes.
Now, my lord, kindly sees Lord, page 56
of
Lord, my opposition. Lord, I am relying on my opposition.
56, yes.
Lord, this is, Lord, kindly sees, Lord, an application for extension of interim order. Lord, this, Lord, has been filed by, Lord, us. Lord, kindly, Lord, comes to page 73. Lord, kindly sees, Lord, the affidavit.
Yes.
Lord, kindly sees paragraph 1.
Yes.
Lord, I am a partner of the appellant firm. Lord, what was shown that he was pursuing the proceeding after the death of P. Mollik alone. Right? Pleading was shown to my lord.
No, from where Mr. Bose showed something from the affidavit?
Yes,
Mr.
yes.
Bose?
Lord, one of the affidavits. Huh?
Page 94 of the thicker paper book, that is the affidavit of Pareshnath Mollik
In the
in
stay
the
application.
stay application in this court.
Yes, and this is
Stay
the
application.
extension application.
My lord.
The
Let
stay
us see
application
side by
of the
side.
second
Page,
appeal.
page.
Page 94.
Oh. All right, yes.
Now, my lord, kindly sees.
Yes.
Lord,
I am a partner of the appellant firm.
my lord.
But
Now,
when did he retire according to you?
Lord, 2013.
After this?
Yes, yes. Now, my lord, kindly sees. And why, my lord, I say, my lord, 2013, my lord, he retired. The factum of his retirement is known to them. Hence, my lord, in the contempt application, when he is arrayed as a contender number 5, he is not referred to as a partner. So they know, my lord, they are aware of this. Lord, kindly sees, Lord, page 88.
Yes.
Lord, we, Lord, are aware that when, my lord, eviction proceedings are filed, Lord, landlord, my lord, takes recourse to, my lord, many a things. Lord, stoppage of water, removal of letterbox. Now, removal of letterbox, my lord, was a cause. This was, my lord, brought to the notice of this honorable court by filing an application, which my lord would very kindly find, my lord, at page 88. And Lord, kindly sees page 90.
I am a partner of the appellant firm. Yes.
In 2008.
Yes.
Now, these application, my lord, were served on them. Lord, no point taken that if another the other partner B. Mollik has died, then the firm is non-existent. You are not a partner.
Yes.
Lord, kindly sees page 91. Lord, this is a letter dated 21st July 2010. Here, Lord, they have indicated that we have violated the court's order of status quo by various means, by installation of air conditioners, by inducting partners, this, that. Now, kindly see, my lord, page 93. This
Your
is
reply.
This is reply to on the 26th of July 2010. My lord, kindly see, my lord, on the left hand side.
Taposh Hajra.
Yes,
I've seen that.
I'm grateful. My lord, kindly comes to page
95, the names of other partners are also there.
I'm grateful to my lord. আমার নোটশিটটা জজ সাহেবকে দিয়ে দিয়েছো না? Lord, kindly see page 98.
Yes.
Now, kindly see, my lord. This is, my lord, their retort. Kindly see, my lord, PL Mollik and Company, advocates. Kindly see, my lord, number 2, that he has affirmed the affidavit in opposition, which is in my lord's hand now.
Yes.
And kindly see, my lord, the other partner on reconstitution, who is no more with us today, before his death, my lord, further reconstitution has happened.
Yes.
On reconstitution, the present constituent of the partnership firm, my lord, I have disclosed that, my lord, in my application.
In your application.
My lord, I shall show. I shall indicate to that. I shall indicate to that. So, my lord, in so far as, my lord, meeting their objection is concerned.
So, according to you, your opposition is twofold.
My lord.
One is if their case of dissolution of firm upon the death of one of the partners
My lord.
is taken, then their suit abated.
My lord.
And if not, then the reconstitution they has acquiesced to that.
I'm grateful to my lord.
So these are the twofold stands taken in the opposition.
My lord. My lord, I have, my lord, indicated to my lord that the argument that in the event of death of one of the partners, the firm dissolves. It, my lord, is qualified.
Two partners.
If there are two partners,
death of one dissolves the firm.
Automatically, even otherwise it may dissolve if there is no contract to the contrary. 42.
Yes, yes. But that is not the case here, because your contract states those conditions of taking in new partners.
My lord.
But
and they were aware of this and they have accused to that. Now, what happens, my lord, in the event, if, my lord, there is a provision for reconstitution, means there is a contract which permits reconstitution of partnership, and one of the partners dies, wherein there are more than two partners.
More than two partners is not a difficulty, Mr. Chaturvedi.
No,
difficulty is when there are only two partners.
No quarrels with that proposition. But I have been able to demonstrate that there was a contract of which they are aware, and there have been reconstitutions from time to time.
So, according to you, at no point of time there was only one partner. That's your submission on facts.
That is my submission on facts. And if that be so, then Order 22, my lord, does not come into, my lord, operation at all. In that event, my lord, Order 30, my lord, kindly cease.
Yes.
Lord, kindly cease. Lord, Rule 4. Right of suit on that of partner. Notwithstanding anything contained in so and so, where two or more persons may sue or be sued in the name of a firm under the foregoing provisions, and any of the person dies, whether before institution or during the pendency of the, it shall not be necessary to join the legal representatives of the deceased as a party to the suit. This extricates me from the obligation which Mr. Bose wants to cast on me by operation of Order 22, that PL Mullik died in 2021. I have not taken any steps to bring in the legal representatives. Suit abated. So I get back to 42, section 42 of the Partnership Act, where if there is a contract to the contrary, then C does not come into operation, and Order 30, Rule 4, it does not cast any obligation on me, like, my lord, in 10A of Order 22, my lord, obligation of the pleader to inform the court. The firm continues insofar as the proceedings are concerned. It is unconcerned with the death of one of the partners because...
No, Mr. Chaturvedi, whether if the contention of Mr. Bose is to be accepted that there were only two partners at the relevant point of time, then whether Order 30, Rule 4 applies.
Lord, I am not segregating my arguments, Lord, in two
Because
parts.
if Mr. Bose's submission is negated, it's the other way around. If Mr. Bose's submission on facts is accepted, that at the relevant point of time there were only two partners, whether Order 30, Rule 4 applies, because it says,
it does not.
Notwithstanding anything where two or more persons may sue or is sued of a firm under the and any one of such partners. So two or more means either two or three, anyone. Yes.
Lord, followed. Lord, I will not segregate my arguments in two parts. One, if, my lord, Mr. Bose's story is to be believed, that there were only two partners. My story is that there have at all point of time more than two partners. Now, if Mr. Bose's story is to be believed, then the suit abated. Then the suit abated. I rest my case insofar as replying to Mr. Bose is concerned there.
Did not abate. Did not abate. That's the language of Order 30, Rule 4. Please see, where two or more persons may sue or be sued in the, and any one of them dies. So two or more. So let us test for two.
Yes.
It starts with two or more. So let us accept two, and then any one of such person dies. So out of two, one dies, one remains. Whether before the institution, it shall not be necessary to join the legal representative of the deceased. So it can be continued as against one of the partner. That's Order 30, Rule 4. It's not the other way around. Maybe three. Even if three, one dies, two can continue. But even if two, one dies, one can continue in this.
But if
that's reading of subject to correction by you, Order 30, Rule 4.
Order 30, Rule 4, my lord, I am showing, my lord, for the purpose of the argument that I advance before my lord. Why I say the suit abates, if Mr. Bose's story is to be believed, is because, my lord, the long and short of the facts, my lord, given to my lord by the respondent is...
Out of two, one died during the pendency of the suit.
And the proceeding did not abate then. It abated in 2021 when the other partner also died, meaning thereby...
Let us segregate this.
Yes.
Let us test first.
My lord.
Appeal will be coming subsequently. So your primary submission was that if Mr. Bose's submission is to be accepted, then the suit abated.
Yes, I am...
So whether by applying Order 30, Rule 4, suits to abated?
I am coming to that. But I come back to that. But Mr. Bose's submission rests on the fact that partnership is not a juristic person. It's a compendium of persons. If that be so, then there were two partners. One died in 2000. One died in 2000. The suit did not abate. In 2021, the other partner also died, and that it finally abated then.
So according to Mr. Bose, suit did not abate. Right. Appeal abated.
Right. I am coming.
Appeal abated.
Right.
So
I'm coming to that. So if this theory is to be accepted, then identifying the firm to be only a trade name, and the parties sued are in fact the partners. If individuals are the persons, because partnership firm is not a juristic person, it's a compendium of persons. If that be so, then in 2000, when B. Mollik died, the right to the obligation to implead the heirs of B. Mollik would lay on him. Now, when I say that there is a contract to the contrary permitting reconstitution, then Order 30 Rule 4 makes it clear that it does not require death. Is not an eventuality which requires any further action. So I'm citing Order 30 Rule 4 for the purpose of buttressing my argument.
Yes.
That what I am being called for, that Order 22 Rule 10A, I did not comply, I did not inform the court that B. Mollik died or PL Mollik died. B. Mollik died, it's a part of the evidence of PN Mollik. B. Mollik died is also a part of the evidence of PW1.
Yes.
Not only DW1, PW1 also.
Yes.
Now, Lord, kindly sees Rule 1. Order 30, Rule 1.
Yes.
Any two or more persons claiming or being liable as partners and carrying on business in India may sue or be sued in the name of the firm of which such person were partners at the time of accruing the cause of action, and any party to a suit in such case may apply to the court for a statement of name and so on. So I say that a point was raised that when I came before this honorable court, I did not amend the second, the cause title of the second appeal was not amended. The cause title of the second appeal was not amended on the death of PL Mollik. We suppressed this. We did not inform the court. We did not amend the cause title. Now, it came to their knowledge. It came to their knowledge on the 18th of November, they say. On 18th November 2025. 17th. Lord, kindly.
Previous day of the last hearing.
Yes. Lord,
prior to the last hearing.
Yes. Lord, kindly, Lord, takes up their application.
Can 11.
My lord.
Yes.
Lord, kindly sees Lord page 19.
Page
19.
Yes.
Lord, kindly sees Lord. This Lord is the notice which was pasted Lord at the outer door of the firm. Lord, kindly sees the date.
No, Mr. Chaturvedi, nothing transpires on this because even if it is accepted according to you, they were well aware of this in 2021, not in 2025. But the fact is that abatement is not from their knowledge. It is from the date of death.
No doubt about it. No doubt. I'm only indicating the conduct. I'm only indicating the conduct.
Maybe Mr.
I read this. I read this in the light of their statement that they came.
The factor, Mr. I accept that according to you, they were aware of this fact long prior to 17th of November, but they have stated that this is the date of the knowledge. In 2021, they had this knowledge according to you.
It does not stop here. It does not stop here. Now, in 2021, when this was pasted, this appears to be a photograph taken from because this is the notice affixed by us. So this is the printout of a photograph taken of this. I take a photograph on the 21st April 2021, but I look at it on the 17th of November 2025. What do I do in the meantime? What do I do in the meantime? In the meantime, I file an application before this honorable court saying that the rent be enhanced, the occupational charges be enhanced. I proceeded with that.
Mr.
I went to the
Shostak,
honorable.
Even assuming your endeavor will be to show all steps taken by them are nullity. That is the highest which you can argue.
But I am.
Even if that is accepted, they have not got any favorable order on those proceedings. So even if it's a nullity, nothing you can not say. Take
My
any
last
advantage out
statement,
of
my last statement, my lord, it qualifies whatever I am saying. This only shows that the knowledge was there, but they did not want to face this honorable court on the merits of the case, which was being argued at a time. Only, my lord, to procrastinate, my lord, this application and the plea, my lord, has been taken.
Chaturvedi, this would be a very good argument, only this part. If Mr. Bose was trying to delay, you are trying to now, after all, the appeal was being taken up. So whether they was trying to delay or not, let us not go into those issues. Straight away, let us come to the legal propositions on this.
Right.
Because this delay and other things, nothing transpires now with regard to this.
Very well. Now, my lord, kindly, now, my lord,
Because
takes
this
up.
will be only multiplying some decisions. We will be citing some decisions on the count of.
I would not
Let
go.
us not go into that.
Very well.
Please straight away come to the legal proposition. What is the effect of that?
Very well. So, my lord, in so far as, my lord, meeting the point of abatement is concerned, my lord, I have, my lord, addressed, my lord. My lord, in respect of the judgments, my lord, I shall, my lord, come to that. But before that, my lord, my lord, refer to some portions of my application.
Yes, where is your application?
My lord, that is CAN 12.
CAN 12 to the inter. Yes, what is your application?
My lord, Lord, kindly sees, Lord, paragraph 5. New partners have been inducted time to time virtue of death or retirement of any partner or partners while the suit appeal was pending before the trial court, and such facts were never beyond the knowledge of the plaintiff respondent.
Yes.
Then, Lord, it is pertinent to mention that herein that Mr. So-and-so was a long-standing partner working in the suit premises, was well within the knowledge of the respondent, and documents attached to the affidavit in opposition affirmed by Mr. So-and-so, now deceased, one of the partners in so-and-so. And, my lord, I have, my lord, referred to those documents, my lord, while I was, my lord, showing my affidavit in opposition. Then, it is also pertinent to mention here that in the aforesaid document, signatures of both P.N. Mallik and Taposh Kumar Hajra are reflecting. My lord, I showed that document to my lord. Accordingly, it is most humbly submitted that partnership of Mr. So-and-so in the defendant number 1 was within the knowledge of the plaintiff, who did not raise any objection at any point of time, even in 2010. That on 7th August 2013, the then existing partners, namely P.N. Mallik and Taposh Hajra, both retired on account of the failing in health, my lord, possibly inducting thereby 2 new partners, namely so-and-so and so-and-so. Thereby instruments of admission of partners before the retirement of partners, and on the same day, both new partners, Divanath De and Chondi Bhattacharya, executed deed of partnership. Your petitioner craves leave to produce. Now, your petitioner says that in 2013, the said Taposh Kumar Hajra had died. So before his death, the reconstitution already happened. And then, paragraph 10, CPN number was filed impleading PL Mallik, partnership firm as contemner, Divanath De, so-and-so, Chondi Bhattacharya as partners of PL Mallik being contemner 2 and 3, but PN Mallik, though included as contemner number 5, has not been referred to as partner. Lord, I showed this to my lord. Then, Lord, paragraph 11 is not important. That on 21st April 21, PN Mallik also passed away, and the same was notified to all the concerned, affixing notification of such death on the door of so-and-so. Then, paragraph 12, by an instrument dated 7th of December 2022, Mr. Divanath De one of the partners of PL Mollik with the consent of other partners, simply so and so, inducted Mr. So and so as another partner and accordingly further reconstituted the firm. Your petitioner craves leave. The petitioner states that the petitioner firm, namely so and so, is continuing one and surviving as the same partnership firm as it was on the first day of foundation of sub partnership, despite death or retirement of any partner. So this, my lord, shows that 42 is, my lord, fulfilled. There was, my lord, a subsisting contract to the contrary, thereby the eventuality, my lord, in subsection C, my lord, it does not, my lord, come into effect.
Yes.
Lord, having said this, Lord, I prayed, kindly grant leave and allow the present appeal filed by the to be continued through his present partners. But this, my lord, in effect, my lord, is a prayer before my lord that the appeal has not abated and the present part, the right to sue, my lord, has survived, my lord, upon the existing partners, my lord, who are, my lord, there to contest, my lord, a claim made as against the defendant firm. Now, my lord, in so far as, my lord, the judgments, my lord, cited by my learned friend, my lord, are concerned, my lord, there is, my lord, I wouldn't take much time on that because there is no quarrel as regards, my lord, to the abstract proposition of law that if there are two partners, my lord, one dying, my lord, would not leave any vested right with the surviving partner to reconstitute the firm. Because, my lord, the status of the firm, my lord, changed the moment the first partner, one of the partner dies. So to say that the surviving partner is still vested with the right to reconstitute the same firm, my lord, it would be a new firm.
Partnership.
It may be a new partnership, and for that matter, any number of partnership he can form. But it cannot be, my lord, the self-same partnership. My lord, here, my lord, the facts, my lord, are different. And in such distinguishing facts, my lord, the judgment on these lines, my lord, would not, my lord, apply. And, my lord, in so far as impediment of, my lord, the legal heirs, my lord, is concerned, my lord, kindly also sees that one judgment shown by my learned friend with regard to implement of the legal heirs, my lord, it was in respect of a suit for dissolution of firm. You know, what happens, my lord? My lord, my father was a partner, my lord, in a firm. My lord, he died. Now he had invested, my lord, capital. My lord, he had
his legal representatives may be entitled to the share of the father, whatever amount he wants.
So it is also the
But
nature
whether
of
those legal representatives have a right to be inducted as a partner, that's the other thing to be considered.
and surely not in a suit where, my lord, the right is not which is heritable in nature. Now, my lord knows, my lord, but tenancy right is not a heritable right as such. I cannot say that, my lord, I am a tenant. The son can say that I am a perennial tenant until unless, my lord, there is a contract to the contrary.
56 Act, Mr. Chaturvedi.
No, 56 Act, yes. 56
The suit under which Act?
56 Act. 56
The
Act.
heritable right.
But I say, my lord, there is a contract to the contrary. There is a contract to the contrary that the firm will continue. And the partner, when he, my lord, signs it, he knows that my heirs would not be entitled. Am I clear to, my lord, your lordship? If there is a contract to the contrary, and, my lord, I as a partner, I sign it that my son would not be entitled to any heritable right in the tenancy, then, my lord, it is a firm which is. Now, those, my lord, are my respectful submissions, my lord. I would say, my lord, let the appeal, my lord, be heard, my lord, on merits and the substantial question of law, my lord, which my lord's court, my lord, have been gracious to frame. My lord, have, my lord, proceeded, my lord, quite a distance, my lord, in that, my lord. Let that hearing, my lord, be concluded, and the respondents be called upon, my lord, to continue with the submissions. My lord, may I only? Right to sue survived. সেটা বললাম তো আমি, right? হ্যাঁ। Lord, kindly permit me, Lord, to repeat. Lord, I said, liberty, Lord, the right
Which
to
point Mr. Bose is insisting?
my lord,
I was
right,
telling whether
yes,
this is judgment, my lord, to my learned senior friend was addressing, I missed the point, my lord, whether my independent right to sue, my lord, attached to this premises in question, my lord, even if, my lord, that whether abatement is the German question, my lord, at this stage. The question of abatement, if it's a right to sue, right to defend, right to sue includes, my lord, that if he has filed a suit, my lord, and the appeal, my lord, whether my independent right, my lord.
Do you have any independent right, Mr. Bose?
No, that is why I was
Mr.
asking. But he said that he has raised this point already.
Independent right, Mr. Chaturvedi?
right to sue, that of the firm.
Farm.
Yes,
Right
by
to
the
sue.
farm, not
By the farm. By the
independent.
farm. I stand corrected by the farm.
Independent right to sue is by the partners. That's a different thing altogether. Whether when the tenancy is in the name of a partnership firm, whether the individual partners have a right to sue individually, Mr. Bose, that is a different thing altogether.
No, he said
Mr.
the farm.
Chaturvedi has not made that submission. He has said
No,
right to sue.
Right to sue. Since I missed his point, my lord.
Yes.
My lord, Mr. Chaturvedi started by saying there are two presumptions. He says that as if our application proceeds on two presumptions. Lord, my answer to that is, it is not a presumption, my lord. We are in second appeal. My lord, the second appeal court proceeds with what was there before the trial court and the first appellate court. My lord, from the documents disclosed, my lord, it is apparent, my lord, there is nothing apart from the document disclosed that there were two partners at the time of institution of the suit. And your lordship will see the cause title of the plaint. The suit was filed.
Page.
The thicker compilation, page. No. The first annexure to the paper book, if your lordship will see the thicker paper.
Page 1A. 1A or 1 whatever.
Yes.
Yes.
The firm the suit was against the firm. So at that relevant point of time, my lord, there is unimpeachable evidence on record to show that there were two partners. What I say,
where is that?
My lord, that document I show
Show me.
No, my lord, the notice to the reply to the eviction notice, which I have also made a part of my application, undisputed document, which says name of the firm, there are two partners. There's no name of the third partner. So when I sued the firm, there were two partners. And my lord, the evidence of Pareshnath Mollik, he unequivocally admits that one out of the two partner has died. And I have shown your lordship the other document, which is
the effect of that, Mr. Bose?
No, the effect is, my lord,
If
if you
the firm has two partners and one of them dies,
yes,
what is the effect of that death?
the effect of the death is there is automatic dissolution of the firm. Now,
So
what
if
about
there is automatic dissolution of the
yes,
against whom you are proceeding against?
yes, against
whom you are
the surviving partner for the liability of the firm. 37, the Act provides for it. The Partnership Act provides for it. You are liable against all liable. Otherwise, my lord, what will happen? Suppose I file a suit for recovery of money against a firm. One partner dies. So will my suit fail?
No, Mr. Bose, the question is not whether the suit will fail.
My lord.
The question is against whom we are proceeding.
I am proceeding
against the firm. If you are proceeding, Mr.
Yes.
Bose, against a partnership
Yes.
firm, and your submission relying upon certain decisions is that the firm dissolved.
Yes.
So now you are proceeding against a sole proprietor and not a firm.
The surviving partner, because the liability continues under the Act. Under the Act, it continues. Under the Partnership Act.
You have made that point that I am
Where will I make the point, my lord? There was no occasion to make the point. Suit during the
Suppose all along the suit and the first appeal proceeded against the firm.
Yes.
Both the courts were under the impression that the firm was continuing, not dissolved. Show me anything where it was brought to the notice of the court. No. Yes, this fact you have also not brought to the notice. That's yes, firm dissolved. Now I am proceeding against the partner only. Show me.
No, the surviving partner only.
show
So
me
the
from the-
firm's liability devolves upon the surviving partner.
That case made
Till
out, Mr.
he
Bose.
no, my
Show me
lord.
that case made
No,
out.
if your
Show me
lordship
the
will
case
see.
made out in your application also. Show me that in the suit, this was I proceeded on that basis. Thereafter in the appeal, so now nothing remains.
If your lordship takes my application,
Yes.
which would be, I think, CAN 12.
Your is CAN 11.
Mine is CAN 11.
Yes.
Yes. My lord, kindly take para 2.
Yes.
Ejectment suit 584 was filed by the plaintiff respondent number for eviction of PL Malik and Company, a partnership firm of which Baladev Mullik and Pareshnath Mullik were partners. It is an undisputed fact that the defendant in the ejectment suit, the appellant herein, were solicitors and advocates on a partnership firm of which B. Mullik and P. N. Mullik were partners. The aforesaid would be evident from the reply to the eviction notice then. During pendency of the suit, B. Mullik, one of the partners of the appellant firm, died. The aforesaid would be evident from the deposition of the surviving partner, P. Mullik, a true copy of deposition we have annexed. Then ejectment suit was decreed in February 2003. Aggrieved, the appellant, through Pareshnath Mullik, filed an appeal before the Learned City Civil Court at Calcutta.
So appellant meaning
The firm.
Through one of the partners.
Yes, that is the surviving partner.
The existence of the firm. That's your positive statement in the application.
No, my lord, if your lordship will see, through Pareshnath Mullik.
Yes.
Yes.
Firm through Pareshnath Mullik. It's the other way around what you are submitting. So you are submitting the firm is being represented by one of the partners or a sole partner. So existence of the firm, you are also admitting in this application. It could not have been if your argument was
My
accepted.
lord, what I admit may be irrelevant. My lord, if what my learned friend said, acquiescence. My lord, there cannot be acquiescence, estoppel,
Against law.
res judicata against law. My lord, this is too well settled the principle. So what I accept, what I do not accept, what I say in the contempt petition may not be relevant. But the only relevant factor is that once one of the two partners died, could I have carried that action against the surviving partner? And whether whether my decree is a valid decree against the surviving partner?
Did you raise any point of mentality of the first appeal?
No, I did not. I did not. But the situation
was continuing at that point of
yes, even I did not raise that objection when the second appeal was carried to this court by P.N. Mullik, the surviving partner. Because our contention all along has been that the interest of the firm, the liability of the firm continues with the surviving partner till it is discharged under Section 37 of the Partnership Act. Because your liability continues.
Yes.
Lord, only one thing, Lord, I wouldn't interrupt, and Mr. Bose would not take an exception to this.
No, I will not.
He's taking exception, Mr. Arjun.
Lord, only Lord, kindly sees Lord paragraph 14
Yes.
of his application. Lord, what my Lord is Lord looking for is there. I only want to indicate, lest Lord it gets missed. Paragraph 14, where the fourth line, as such, the surviving partner at best could have been in occupation or in his capacity as a surviving partner. So he recognizes the firm. Lord, this is not my Lord's query, my Lord. This gets answered here. I'm sorry.
Yes.
Yes. What? Sorry. You will know?
I indicated only paragraph 14. Thank you.
Watch very well.
Yes.
So thereafter, my lord, I was at paragraph 7. No, I stand correct.
Paragraph?
Yes, I was at 4.
Yes, paragraph 4 of your application.
Yes. Then, my lord, your lordship will take 5.
Yes.
The said appeals to dismiss agree Pareshnath Mullik in the name of the appellant filed a second appeal before this honorable court. If your lordship will see the cause title, same, and he says Parashnath Mollik has filed the second appeal. So that is also another admission on the part of Parashnath Mollik, the surviving partner, because he has not said I am filing this application as a partner of the firm, because he was conscious of the fact that after the death of his other partner, there could not have been other partners apart from him. So he filed it as Parashnath Mollik itself. He did not say one of the partners.
How a suit against a firm is to be filed?
Order 30 Rule 1, if your lordship will see, it can be sued, it can sue, or it can be sued in the name of the firm.
So here it can be sued.
Yes.
In the name of the.
Yes. I
So you
framed
have
the suit.
Captioned your suit as against a firm.
Correct.
So you have not looked anything beyond that name.
And in the evidence before the trial court, it became evident that there were two partners of the firm when I filed the suit. Because prior to filing of the suit was my eviction notice. That the eviction notice stood answered by the firm, two partners of the firm. And then after I filed the suit, so when I brought the action,
Two partners.
two partners. Now, my lord, the only issue that needs your lordship's
Couched your or the cause title as such and such firm represented by such and such partners.
No.
That you have not done.
No, I have not
Your
done.
framing of the suit is against such and such
Yes.
partnership firm.
Yes, yes. So that's why, my lord, your lordship will see. Then that Rule 4, Order 30 Rule 4, applicability is not there. Now, my lord, the result is that when there are two, this is a completely different situation altogether. That's why I showed your lordship those judgments. They are on all the judgments are on the situation where there were two partners. And not from 66 till date, well, it has been the consistent view of the Supreme Court that the firm dissolves. So now, my lord, there is no doubt on the proposition that in a firm of two partners, when one dies, it dissolves automatically.
Now,
42C doesn't apply.
After that, how a suit against the firm is to proceed?
Yes.
Law on that.
And what's the law on that? Well, kindly take the Partnership Act itself.
Yes.
First is, does my right to sue survive? Because I cannot proceed against a dead person. So, my lord, my lord, I have to pursue against somebody who is a juristic person who's recognized in law. The recognized person in law was P.N. Mollik, the surviving partners, because he, as a surviving partners, there were two estates, the deceased partner's estate. Upon dissolution, there will be rendition of accounts under the Act. So under the rendition of account, one will become the estate of the deceased partner and the other will be the continuing partner. So the liabilities of the firm has to be paid out of the firm. And so the estate of the deceased partners will also be computed after the liabilities are paid out. So the surviving partner, the liability continues with the surviving partner. Now, if your lordship kindly takes section 37 of the Partnership Act. Where any member of a firm has died or otherwise ceased to be a partner, and the surviving or continuing partners carry on the business of the firm with the property of the firm without any final settlement of accounts. Now, my lord, pausing here for a moment, my lord. To apply section 37. My lord, to apply this principle, my lord, the two things we need to take into consideration. A, the tenancy was a interest of the firm. The rent receipts were granted by the landlord in the name of the partnership firm. So this was an interest in the suit property.
কি ব্যাপার?
So, my lord, this interest of tenancy was with the firm. So, my lord, if it is in the interest with the firm, so now if your lordship applies 37,
Yes.
so the partners were enjoying the interest that was with the firm. Where the member of a firm has died or otherwise ceased to be a partner, and the surviving or the continuing partners carry on the business of the firm. My lord, again, P.N. Molly carried on the business of the firm. He continued to be a solicitor. He carried on business from the tenancy with the property of the firm without any final settlement of accounts as between them and the outgoing partner of his estate.
So another important thing is that without any final settlement,
Correct.
where is that case made out?
Well, I don't need to make out. Onus is on them to make out.
Mr. Bose, you are trying to rely upon this.
No, I am saying your liability continue.
It's made out that according to Mr. Bose, you have to make out this case.
Yes.
37, it's liability upon. So that is why in this during the pendency of the suit, you ought to have pointed out this. Yes, it's his liability. Now I'm proceeding against that sole surviving partner in view of section 37. Once you make out this case, it was obligatory upon their part to show whether there was settlement of accounts or not.
No,
But you continued with that.
because my property is being enjoyed by them. So my only interest is to get back my property.
Suppose you did not, because the carriage of proceeding lies with you.
Yes.
Carriage of proceedings lies with you.
Yes.
You ought to have brought to the notice of the court this fact. Look, the firm has dissolved. Now I'm only proceeding. It's only this partner who is continuing. So liability is with him. So I'm proceeding only against them. So there has to be an amendment to that effect, because now the firm no longer remains once it's dissolved. After it's dissolved, can you continue with the firm's name? Maybe the liabilities, maybe the tenancy, but whether you can continue with the firm name.
If your
after
lordship will
dissolution,
see,
cannot be done after dissolution.
if your lordship will see the 66 Supreme Court, the 66 Supreme Court is an answer to this. Because my action against to get back my property was against the firm. So your lordship is saying if by operation of law the firm has dissolved,
You can proceed with the surviving partner, but there has to be a statement on that. That look, in view of this, firm no longer remains. It has dissolved. Now this is the sole partner who is continuing with that tenancy as a surviving partner. I am proceeding against him.
very well. Well, now, my lord, I will address that query of your lordship as well. But now your lordship will kindly allow me to continue this. There is
Because
one more.
once you continue with the firm, anyone comes. That's the difficulty.
No, anyone cannot come.
That's-
That coming portion has been answered by the Supreme Court.
Sir, both there are two things.
Ah.
Here lies whether the reconstitution they can take advantage of or not. Once you say no,
Ah.
he is the only firm gets dissolved. That is also not the case made out by you. Because Mr. Bose, carriage of proceeding lies with you.
Yes,
You
so
have
what
to
I
take
did,
steps.
I carried the proceeding
Yes.
to a conclusion against the firm and got the decree.
Could not have. When you had the knowledge from the evidence, one of the partners died, consequence is dissolution of that firm. If the dissolution of the firm, now you could have said, yes, in view of that, I'm proceeding against this partner. Because he
Because-
is now continuing with that.
My lord,
You also proceeded as if the firm is continuing.
because according to me, since the other partner was surviving, I could continue.
That is either way. If you rely on those judgments, it's that
No,
demolishes
but
your
then,
case.
but no,
Firm dissolves.
no, but
If
if
the
your
firm
lordship is
dissolves, you could not have continued with
no,
that
but then I can continue. I can continue against the surviving partner
surviving
the firm.
partner.
To the firm,
Cannot be-
because if
Mr.
the
Bose,
liability
how
of the
firm
firm,
continues, firm dissolves. Maybe the interest of the farm, he is continuing the liabilities. But the farm is no longer in existence after it is dissolved. Can the farm remain after it is dissolved?
No, if your lordship will see, the firm does
He
not.
cannot also represent, because farm cannot be represented by one partner. Maybe the liabilities and other things, he is bound by that.
Yes.
So he will be bound by the liabilities of the farm.
Yes.
But he cannot continue as a farm.
So the effect is the same.
No, effect is not the same.
Well, today, if I
Decree
get
passed,
yes,
not in the name of against a right person. Decree passed against the farm.
against the firm.
Farm is no longer.
So the firm's interest that I am saying the firm enjoyed something I gave to the firm. The firm came to an end. That interest continued to be enjoyed by the surviving partner.
So now the
So
farm is, Mr. Bose, the farm is no longer in existence. What you are submitting, it could have been then through that PN Mullik or so.
whatever.
So the plaint ought to have been amended for that. You are
No,
now
but
proceeded
let's
with regard to that, because the farm
let's proceed, my lord, on the basis that if the amendment was not carried out, what would be the effect of the decree that was passed? So the decree was passed against the firm.
which is no longer in existence.
So the firm.
The decree will be a nullity in that case.
So that is what is required to be examined. So if your lordship will see,
Decree passed against a farm which was no longer in existence.
which by operation of law dissolved.
So it was no longer in existence
And
as on the day when the decree was in the suit was passed.
so now your lordship will see, then the situation is that the suit is contested by the surviving partner and it is brought to a logical conclusion and a decree is passed. The decree could have been passed otherwise also, my suit could have been dismissed also. So I am on the decree that was passed. So whether by virtue of the fact that I continued against a fund which dissolved and I continued in the name of the firm, would that make my decree a nullity? My respectful submission, though it is, well, the decree doesn't become nullity, because if your lordship will see, the firm is a compendium of persons and the trade name is the name of the firm. So it is the effectively, if your lordship will see, in fact, one of the judgment records that, if your lordship sees that, I think.
Yes, you have placed that. It's a trade name.
Trade name. So I proceeded against the firm effectively mean I proceeded against the partners of the firm. So the fact that the trade name or the firm by operation of law dissolved, that in my respectful submission legally will not change or alter the position of or the status of my suit. Now, my lord, if your lordship comes to the liability part, if your lordship
37.
is 37, another section is there.
Yes.
But also kindly take
37, I stopped you in the middle. You can
Yes.
complete that.
Yes. I was there. Has died or otherwise ceased to be a partner, and the surviving or continuing partner carry on the business of the firm with the property of the firm without any final settlement of account as between them and the outgoing partner of his estate, then in the absence of a contract to the contrary, the outgoing partner or his estate is entitled to the option of himself or his representatives to such share of profits made which is ceased to be a partner as may be attributable to the use of his share of the
right of
property
an
of the
outgoing partner, Mr. Bose. It's not any right given to you.
No, I am not on that.
Or the continuing partner.
Correct.
It's the right
So-
of the outgoing partner.
So
it could have been if PN Mullik has retired, what was his rights? That is 37.
vis-a-vis the other partner.
Yes.
And
that is
and
37.
my lord, then your lordship,
Nothing to do, does not give you a right, anything.
possibly my right, your lordship.
Outgoing, right of an outgoing partner inter se with the
Right.
surviving partners
Right.
or the continuing partner.
Correct. So this is clear, my lord. So he had a right, he had an obligation so far as the estate of the deceased partner is concerned.
What is
Why?
inter se?
No, why, my lord? Because he was using and he continued to use the firm, the asset of the firm, which is the interest of the firm. Because he continued to use, it was a tenancy in the name of the firm and he continued to use that. So his obligation was there under 37. Now, my lord, kindly take section
Intersay.
45.
That was Mr. Bose. It's intersay the rights of the outgoing partner with the continuing partner. This has nothing to do
No,
with
I am not. I am taking that analogy and applying that the surviving partner, PN Malik, once he continues with the interest of the firm, he continued to be liable for the firm as well. Now, my lord, kindly take section 45 once.
Yes. Yes.
Notwithstanding the dissolution of a firm, the partners continue to be liable as such to third parties for any act done by any one of them, which would have been an act of the firm if done before the dissolution, until the public notice is given of the dissolution. Provided that the estate of a partner who dies or who has adjudicated insolvent or a partner.
45.
Section 45, liability or acts of a partner done.
Provided that.
Provided that the estate of a partner who dies or whose adjudicated insolvent partner, not having been known to the person dealing with the firm's to be partner, retires from the firm, is not liable under the section for acts done after the date of which he ceases to be a partner. Now, my lord, if your lordship will see, this section continues the liability of the partner who uses the business of the firm after the death of one of the partners. He continues to be the liable for the firm. So what my only limited submission is that since PN Malik continued, if he had gone out after the death, things would have been otherwise.
PN Malik would be liable. Then who would be liable? PN Malik would be
That
liable.
is my that.
But here PN Malik, you are not proceeding against PN Malik. That is what I wanted to point
No,
out.
my lord, if your lordship will see.
Wanted to proceed against the firm, not PN Malik.
Well, this has been well settled in that Waldorf judgment. Trade name, nothing more than trade name. It is the partners. So my contention today is something very different. I am saying that today, after the death of PN Malik, what is the situation? Two partners, there is nothing on record to suggest that as on the date of the decree, there were any other partners which has come in. Well, apart from my lord, what has been submitted from the bar, there is nothing on record, either before the first appellate court, trial court, nothing.
Can you show me from any of the judgments of any of the courts which recognizes this fact that there were only two partners? Please show me from any part of the judgment of either courts. Because all these are evidences, no courts have decided on that. And you are trying to show
No, my lord,
when
there
it
is
to an eviction notice, they are trying to show some statements in the affidavit, you're certain. So these are no adjudication. Show me at any point of time, any of the courts went into this fact. Who are the partners? These were the two partners and such that none of the courts have gone into this.
No, not required to go into. Why was that requirement was not there? Well, that requirement arose.
Enter into that.
No,
Facts
because it arose
that was
today.
two partners, then no reconstitution. These are the factual findings.
No, but today it is an admitted fact that I sued. When I sued, there were two, and today both are dead. So now the question is that does the right to sue survive or not?
Mr. Bose, this
My
has
lord.
to be considered on the basis of the evidences that were placed, though none of the courts have rendered any finding on this as to this PN Malik and Company or PL Malik and Company had how many partners at the time and what it happened, because neither the decree also, nowhere the names of the partners, apart from that letterhead which was produced in reply to your eviction notice. Apart from there, nothing is there that there were only two partners.
Correct.
No adjudication on facts.
No, my lord, if your lordship will see, there is evidence. On record, there is evidence and one died. So nobody is disputing that part of the evidence.
There are many other evidences, Mr. Bose, if I have to go into that, this factual finding, because he is also stating something on affidavits. Those are also to be taken into consideration.
No, I am saying the
Anything,
death is
because
not disputed. The death of B. Malik is not disputed.
No. So the question is whether this right from this inception of the suit till the passing of the decrees, how many partners did that partnership firm had? There is no finding with regard to that. Can you show me any document to show, yes, there were only 2 partners till the passing of the decree?
The partner himself, the partner's admission is there. Well, that cross-examination, he himself says, the other partner. B. Mollik is that I am the other partner. So that I am.
Evidence, Mr. Bose, has to be read as a whole.
Yes, of course, of
Culling
course.
out 1 or 2 sentences
So he has
and
not.
cannot be interpreted, Mr. Bose, as a statute.
No, I am saying.
Statutory interpretation, some words can be interpreted in one way. Evidence, something has been stated.
Two evidence. The reply to the eviction notice, which has gone in as an exhibit, which says 2 partners, name of 2 partners, not in dispute. That has gone in. It's an exhibit in the suit. Then the cross-examination of the partner, surviving partner, that the other partner has died. Then next evidence before the court, P.N. Mollik files an affidavit here in his capacity. The other records. So these are my lord, unequivocal admission. This situation has not changed.
Yes.
So, my lord, now your lordship will see. Then, my lord, my next contention would be, based on what my learned friend has said. Well, acquiescence, I've already said, no, there cannot be any acquiescence in law. Whatever I have said in the contempt petition, that is immaterial, but the fact remains. Then he says that reconstitution is a fact. Now, my lord, this fact, surprisingly, your lordship will find that is contrary to the admitted evidence on record.
Why? You have stated something.
I may say, no, I have said what? I have.
That is why I'm saying there is no adjudication by any authority. Now I'm posted with very many evidences.
No, I'll tell you.
One is reply, certain other things on affidavit filed by you, making something. So these are the evidence which is to be considered, and finding is to be arrived on that. That is what I'm saying. I cannot only rely upon one.
No,
evidence.
no, of course not. Of course,
So
what
everything.
Well, I possibly
Filing of an affidavit stating something, you cannot also come out of that.
No, I cannot. What I am trying to contend before your lordship is that, my lord, before the suit was decreed, now against whom did I file the suit and against whom the suit has been decreed? So this is all, my lord, continuation of the suit. Suit filed admittedly against the firm. 2, one died during pendency, the other continued. The other partner brings the appeal, the other partner brings in the second appeal. My lord, then during the pendency of the second appeal, everything has happened. Now, my lord, what is the, would the subsequent facts during the pendency of the second appeal, reconstitution, would that be of any relevance?
No, sir. Reconstitution is not at the second appellate stage. It's prior to that.
No, my lord, if your lordship will see, there is
prior to that.
No, there is no
all along reconstitution according to them.
No, them where? Who has said that where? P.N. Mollik has never said. There was no third person except P.N. Mollik. P.N. Mollik has never said that there has been reconstitution at any stage, whether before the first appellate court or before the second appeal. That's why I showed your lordship, and we have annexed that document, the affidavit to the second appeal stay application. Otherwise, he would have affirmed it as one of the partners.
Why have you not implemented P.N. Mollik as a partner in the contempt application?
Well, contempt application appears to be a mistake.
Is your justification for claiming that there has been violation of the order regarding induction of certain partners?
Your lordship can record below. That is a question. That's it's a mistake of fact. It's a complete ego.
Maybe, Mr. Bose, this even if a suit is withdrawn, admissions remain. Admissions you cannot withdraw.
No, I am not saying that. Those admissions are when?
Even if you withdraw, even if you say today, no, I'm not pressing my application for contempt.
No, lordship will see the contempt.
Pending, because you said it's pending. Even if you withdraw, admissions remain.
Yes. Now, my lord, kindly see what have I said in the contempt application.
Suit may come, suit may go, but the admission remains. 72 is CWN 805, Justice KJ Sengupta.
Admission remains, and admission has been made at what stage? And what is the admission? So that is relevant now. Now, my lord, kindly have a look at the contempt application, which is a part of their affidavit in opposition.
What's the admission?
17 and 18. I think that is what Mr. Chaturvedi had relied upon. 17 and 18, paragraph 17 and 18, your lordship will find
Starting
that
from the cost title, Mr.
page
Chaturvedi has
35.
placed, because your the acts of contempt you have specified in page 22,
Page?
point numbers 4 and 5,
Yeah.
becoming partners of such. That was the cause of action for filing your
Hmm.
contempt application.
Yes.
Inducting 2 new partners
Yes.
into such and such. Then, so this was according to you a ground of contempt. And next, how have you?
So, my lord, pausing
you
here
have
for a moment, pausing here.
Contemners, that is
I
25,
accept. My lord,
26, along with those
my lord, kindly
paragraphs.
see this. This was an act of contempt. I was complaining that an order has been violated. So the order was passed in the second appeal. So when I complain of the alleged acts of contempt, so they have been done after the second appeal. So I am complaining that new partners have been inducted when after the second appeal.
Where have you stated that?
No, my lord, this is the
no,
inducting two partners into the partnership firm. The act of contempt.
Mr. Bose, whenever you stated that when they were admitted as a partner. Tell me. And what is the evidence in your support?
So
You have
because
said, Mr. Bose, admission is they were inducted. With regard to the date, there is no admission. Do you mean to say when, at what stage you will be filing an application that from that they were inducted? That
no,
cannot
I
be.
did not say that.
Admission is there were some partners were inducted.
Yes. So if
Apart from that, there is no admission at what stage on which date. Whether it was during the pendency of the suit, first appeal, second appeal, no admission. Only admission is some partners were inducted.
So let me rephrase myself. What I was trying to, my lord, contend before your lordship is that there is a contempt application filed for violation of an order. Well, what was the date of that order of which we complain of violation? 8th of September 2010. So today, if I am complaining, so there has to be, that act must be after the date of the order. Only thereafter the question of violation will arise. So prior act would not constitute a violation of an order under the Contempts of Court Act. Now, my lord, if your lordship will take paragraph 17 of the application. Yes.
That is on merits.
My lord.
That while the contempt application will be decided on merits, that maybe that if it is found that yes, partners were inducted prior to that, maybe your contempt application may be dismissed. That's the other thing. That's on merits, whether the contempt application will be getting an order or not. So those things can be gone into at that stage, not at this stage that yes, since you have filed, it presupposes that it has to be after, since you have alleged. So the tenancy induction, the partnership induction was subsequent to that.
So averments made in the contempt application, by referring to the averments made in the contempt application, they are saying that I was aware.
Yes.
They say that
is only
I was aware of the reconstitution.
Yes.
So let's say, for the sake of argument, my lord, I was aware. Even if I was aware,
it does not benefit them.
Does not benefit them. But the law says
partnership should dissolve, cannot be, even if it is a new partnership, not the reconstitution of the partnership.
So, my lord,
that's your argument on.
Yes. So now, my lord, this is, with respect, my lord, this argument of my admission in the contemporary is inconsequential so far as the issue to be decided today. The limited scope of the issue that requires to be decided is whether PN Mollik's death, by virtue of PNL, whether the present appeal abates or not, and whether, if there has been reconstitution, whether the partners of the reconstituted firm have a right or if this right to sue survives with them or not.
Continue as partners of the original firm. That's your submission.
Yes.
Even if reconstitution has taken place,
Yes.
they cannot claim to be the partners of original firm.
Well, Lord, much has been said about us. Much has been said about our conduct. But allow me to show you, Lordship, one provision of the Civil Procedure Code.
Yes.
But kindly.
No, your conduct, Mr. Bose, I have stopped Mr. Chaturvedi from making any argument on that.
I am saying that.
He has not made submissions. So I have stopped him from making any submissions.
No, I am on. This is a legal obligation under the. If you, I am sure you.
Yes, which provision?
But kindly take Order 22, Rule 10.
10 capital A.
10.
Rule 10 capital A.
Yes, 10 capital A.
Yes, where is the recent decision, Mr. Bose, on that, considering Order 22, Rule 10 capital A?
No, but one we gave 3 to your Lordship, but your Lordship said those 3 are not the ones. There is another one, it doesn't become a nullity. But the ones we are taking out in the recent in 2025, they
get time in this weekend because I was not here. That is why.
No, I am only on. I was referring to 10A only for the purpose that
2210A, Mr. Bose, is it does not stop abatement. It does not stop abatement.
oh, it has really got nothing to do with abatement.
Abatement runs or
Date.
starts with effect from the date
of death,
even if not communicated.
Regardless.
Non-compliance of Order 22, Rule 10, capital A, may be a very good ground for setting aside abatement. That's a different thing altogether. So whether the abatement can be set aside, he may say, no, I was not aware. That please can be taken. But the abatement took place with effect from the date of death. That cannot be stopped. As in your case, firm dissolved upon the death of the other partner.
Yes, 2021.
Yes, upon the death of the other partner.
Yes.
If that death took place, now how the suit was to be, because carriage of proceedings at the trial stage lay upon you. How or what was your obligation or how that suit ought to have been proceeded with by you. That is to be considered till the passing of the trial court's degree. Thereafter, everything carriage of proceedings upon them because you have succeeded in the suit.
Right.
So first appeal was also by them, second appeal was also by them. So your endeavor is to show that what steps or how or what steps ought to have been taken by you.
And whether my decree is not a nullity.
Yes. Whether under such circumstances, if the firm dissolved, proceeding in the manner as the suit was filed, whether the decree is a nullity. If the suit abates, everything goes.
Very good. So your Lordship has to attend a full court reference today.
Tomorrow?
Kindly don't take it tomorrow or day after. I am not there. Nay, I'm not there tomorrow or day after.
Well,
traveling. Well, your Lordship, we need some time to do some research and come back with something effective.
Today evening.
No.
Mr. Bose, you know because that is why I am keeping it.
Hmm.
Because from motions from 12 p.m., the motions are stalled. Because I am not adding the other hearing matters of Group 1 also. Because this is, since there is a direction, that is why.
Yes, yes. My Lord, now we are.
And it's for your benefit, Mr.
Yes,
Bose,
my Lord, it
because
will.
You wanted this.
Correct.
That is why, because after this application, then the main appeal has to be taken up.
জাজমেন্টটা জজশেপ দিয়েছিল এদের হয়তো দিতে পারে তুমি বললে না আমরা তুমি একটা দিন আমি দুটো দিন এয়ার 70 ক্যালকাটা 99 বলেছিল এছাড়া কি দিচ্ছেন
So that view has been diluted, Mr. Bose.
I was
You have their judgment.
The last one which your lordship was referring to, my lord, regarding the independent right, your lordship was referring one judgment of the Supreme Court. Of late it has been passed 2 months ago. My lord, that is why I was asking.
Because the initial view was that 70 Calcutta, if that is applied, then Mr. Bose's suit goes. Then he has to approach at the trial stage for setting aside that abatement, if the suit goes. Now, or if the suit was right, then the appeal, at the appellate stage, then your appeal goes. That's the other way, because 70 Calcutta says, even if it is in ignorance, you are not aware, maybe the other side has not informed, that will not stop the abatement. And you cannot take that plea in the subsequent stage. You have to be relegated to the stage where the abatement took place. So if the abatement took place in the suit, then if the carriage of
It is
proceedings may
automatic
be-
by operation of law by default.
Yes, but
Abatement.
now 70 Calcutta has been diluted.
That is why I was asking.
That is 70 Calcutta has been diluted considering this order 20 rule 10A. That was considered.
Citation টা দিয়েছিল আগে
The
কিন্তু।
difficulty is I do not remember the judgments as you. The Kollol board. That's the difficulty.
I was also looking forward to Mr. Kollol also.
এই তো তাহলে আমি বসে যাই।
This is the one. But can we come back on Tuesday, second half,
আরে
my lord?
ভার্চুয়ালি করো না কালকে।
Tuesday, Monday. I mean, I stand corrected.
The week.
No, no, no. Wednesday, second half. My lord, your lordship is saying tomorrow. Instead of tomorrow, I am saying Wednesday, second half. I am not there. The only difficulty is there. Thursday, I would have prayed for Thursday.
Mr. Chaturvedi?
Thursday অসুবিধা আছে?
Milord,
Not Thursday.
Wednesday, Milord, I am
Wednesday?
yes. Thursday, Friday, and Monday, Milord, I would not be there.
You have a battery of competent advocates to assist you. Mr. Bose is there,
বুধবার
Mr.
কর না।
Owen Banerjee is also there.
Yes.
So that time I am assisting.
So they are there.
বুধবার
So
করে দে না।
হ্যাঁ বুধবার করো।
Wednesday,
2 p.m.
No, my lord. Can we?
Mr. Bose, how much time you will take?
I will not take much
How
time.
much time?
10-15 minutes maximum.
10,
I will
15?
see whatever about or maybe maximum no more than 30 minutes. If your lordship keeps it at 3 o'clock, I will come back by 3.
Then I'm doing one thing, I'm keeping it at 3:25.
Milord,
With an understanding
risk হয়ে যাবে।
that
সাড়ে
even
তিনটে
if
হয়ে যাবে, এই সাড়ে তিনটে হয় কোর্ট।
it will continue.
We'll continue. We'll continue. We'll
That
continue.
understanding?
Yes, we'll continue.
I'm
We'll
keeping it
continue.
at 3:25.
We continue. We continue.